Mr. Advocate General.
Item number 33, the content maker. I have taken the content of the other side. In the last night, the ONGC have informed the right of the appear at this point and this is the brief. So, if you take up
36.
item 36,
Okay.
Mahmood Ali versus Anil Kumar. Here, the position are all from ONGC.
What is that?
We have to it is not included.
You have filed the affidavits.
Like on Friday.
Okay. We'll see when the matter is taken up. We'll have it on day after. Not now.
No, my colleague will be there. I don't have it for listing on my not similar matter. It's not the concept of the other side that will try number 393. I say for I can figure.
What is the matter about?
Non-permanent of hydrogen fever. Non-permanent of
Asking for time, why?
I displayed the finder.
Okay. If the instructions have come, these are police matters. The instruction. So let us pass orders to that effect. Otherwise, your matter will go after 4 weeks. Would you like that?
No.
Then don't mention it.
I tried for I for in item number 25.
You want to bring it?
So I need to mention for instance for regulation for attention next Friday or Monday.
Next Monday.
Next.
By the reply in item number 49 of the supplementary. Right.
Question of tax. In fact, already before your business account,
number 1 person. From the metaphor for today, and may single out of national or person.
What is the matter about? The request of the Learned Counsel for the petitioner, matter stands adjourned to be listed again on 15th.
Not the lordship. I need to mention item number 38. If the content the matter has been already complied by the department. The matter is no influential.
Mr.
Yes, ma'am.
S. Midhi. The Learned Counsel appearing on behalf of the petitioner submits that the order dated
39,
13
2020.
passed in oblique
20.
have been duly complied with. So taking into account the above, the instant contempt proceedings accordingly stands dropped.
Like the similar they are in item number 40. Order dated 25 complied.
In writ petition number
711.
Mr. R. S. Chauhan.
Number 70. ONGC filed an affidavit on last
70. I have so many matters.
Supplementary.
Yes.
Filed an affidavit on Friday.
I like to mention predicting of the matter for motion here. This matter was last listed on 19th year, and on prayer, the lordship was pleased to link the matter for 4 weeks year. Your similar matters are listed on 10th year. If your lordship allows, I pray to list the matter here.
The final rejoinder and item number 71. Document please. Bottom line.
I, for what? IA civil for motion? What is this item? Why are you filing the IA civil?
For amending the prayer.
So you are therefore seeking an amendment to the writ petition. Okay, we have it on 15th.
50. Right. Yeah, I think you know, court road, so I find the first one. That goes for court.
You have not filed affidavit.
We have filed on court, we have filed on.
Okay, you want to bring it.
Yes. Limited item 57, 6:30 AM.
Yes, instructions. Yes, what is the reason why you have given it? You have received the instructions just now. Okay, give a printout, we'll take it up at 2. At 2, get your instructions printed off.
10:30 AM.
Huh? Where's your instruction? Okay, at 2.
For motion item 2.
Yes, who is appealing in the matter? Yes, Mr. Gogoi, what is the matter about?
We have surrendered.
You have challenged the?
Trial loss it days 20 loss. And. Yes, 2 euros. That's it.
If it is being confiscated, isn't it required? Why is the writ petition filed? Huh?
Section 6 of Essential Commodities Act has a public problem.
So if the Jimma is not being granted, so against that, a revision should have been filed, isn't it? Why should this court exercise 226? So, none appears on behalf of the petitioner. Mr. K. Gogoi appears on behalf of the state respondents. The petitioner herein is aggrieved by the order dated 2/8/2025, whereby the co-district commissioner, Dispur co-district, had confiscated had confiscated various items under Section 6A of the Essential Commodities Act 1955. It is seen that the petitioner thereupon approached the court of the Judicial Magistrate First Class, Kamrup Metro, seeking Jimma. However, the learned Judicial Magistrate First Class, Kamrup Metro, have rejected the said application. It is the opinion of this court that if the petitioner is aggrieved by the said order, recourse is available under Section 4, 5 of the PNSS full funding. So under such circumstances, it is therefore the opinion of this court that this is not a fit case for entertaining the writ petition under Article 226 of the Constitution. Accordingly, the writ petition stands dismissed. However, the dismissal of the writ petition shall not preclude or prejudice the petitioner in approaching the appropriate forum. Same disposed.
Oh.
I just followed in the aspect of the this was gold melon, but that was held to be melon that they cannot be covered by disconnection of
Huh?
earlier expression. Your notice of aquatic function is at page 53.
Page 53.
So it's the part under section 2, page 2. Yes. Or it would be one extra, 25 lakhs.
On judgment.
On the other, because several some cases were there. Okay, 51. That is regarding the
Then
now, whatever after comparing, they started throwing this area against the bills. Then on that basis, they then current at page 61.
page 61.
They are showing the area principal, area started from current started. This surcharge on that amount, they are again realizing it from us.
Where do I get
Take
it?
it on two color.
Page 61, where?
Bottom color. Area principal.
Hmm.
Then area surcharge, then current surcharge. This current surcharge on that other area amount, they cannot be realized.
So you are against the area principle.
Area this current surcharge. Surcharge.
You are only against current surcharge or area principle. Which one? You are against which one?
Against current surcharge.
Not the area principle.
The area principle, they are only showing, they are not for that. But current surcharge, they say that until this current surcharge is paid, they will. So under that method, we have paid for 3 months. Then we are every time. We have, but it depends on method that this cannot be done, but they did not do that.
So you have no problem with area surcharge?
It is such a, no, they are not going now. They are not going. Yes, sir.
So they are trying to recover 39,225
Yes, ma'am. This is, they recovered already for.
recovered from you.
Well, for 3 months I have paid, then I am opposing it. Well, they again, and again, for time bills. Because super teachers, there's a.
But you are also asking that living area principle also in your representation, page 66.
That is already, has to be not recoverable. There is no carry because this school court has already said. So when they are, we went to pay the amount, they are only with this current surcharge there. That is
Where
what
is your
we have.
representation?
That's only page 66.
But kindly see page 68. That's your-
58. So you can wake up and remove the area amount, but they are showing it, that is why I am saying, that should not show in the below.
But why you are not submitting that? That is why my specific question was there to you. But you only, you have no problem as regards the area, principal areas as well as the area surcharge. But you have only against the current surcharge.
I'm showing it another matter, because they are not demanding that, the same amount. They are
But there are, isn't it a notice is being issued?
Yes.
If the demand is being made, isn't it the demand being made?
That is correct. Demanding.
Then
That, correct. That is right. Correct.
now when the court has already held that you can recover it only by way of a civil court proceeding, then why they are making this demand in the bills?
Right. That-
First of all, there is an alternate entity, she has not been interested. I don't remember.
Forget about the alternative remedy. Here is the court's order being passed out there categorically asking that you are not going to demand anything more on this by way of these bills. What you are doing is you want to recover, go and file a suit. But why are you putting all these things out there and asking them to recover this current surcharge, area surcharge and principal in the bill? Tomorrow he wants to do a particular business also, it will be shown as and this amount is pending. Now, putting all these things, you want to extend the period of limitation. You have a limitation period. Now, are you therefore not trying to do so? Although it is not the submission of the learned counsel for the petitioner, which should have been. Unfortunate.
The earlier order litigation, the honorable judge, by following the judgments of Rahmatullah and said that we have our bill which we had raised as per 56 is correct, but we should follow the judgment of Supreme Court. They said that the only what we should do, you should not go for disconnection. To recover the money, you should go for the recovery mode should be there.
What is your recovery mode?
Recovery mode is like we should go for filing of a money suit for a.
Therefore, you go there.
Yes, ma'am.
Why you are putting it in the bills?
My lord, may I just submit?
Yes.
My lord, let me get instruction on this, what is a proper motion. So my lord, there's a representation being made. So let me just give
The
me-
representation is properly made, but the council has made a wrong submission. But then also,
My lord would, would judge-
no, first of all, you can't put this
Yes, that's, my lord.
because the direction is, it amounts to a violation of the court's order. Court has categorically said that yes, you have a power to recover, but the recovery has to be meted out through the means, that is filing a suit.
Yes, ma'am.
Rather than what you are doing is, this order was passed as far back as on 29/5/2024.
Yes,
You have not taken resort to filing a suit, rather you are putting it in the bills. Which categorically therefore shows that you are trying to undermine the majesty of this court or the rule of law.
I put on the motion.
You need to take out all these things from there.
My lord.
And whatever amount you have taken it out there has to be adjusted against future bills. But these amounts out there, there's no quarrel, you can file a suit. After that order has been passed, why you're not filing, 3 years will go by. After that also you can, now we are already in the late part of 2025 is over, so 2 years is almost over. Then
My lord, the council of Wednesday, I understand instruction of the-
you should remove all these things, whatever all these these things, and you file a suit. Don't do like this.
My lord, on the last occasion, my lord, we went on the last Thursday, there was a hearing that happened. Mr. Kejriwal was on with the cell. So this issue, my lord, that was a very some with regarding to the school on bail. As there is a CGRF and there is an compulsory is there, so you should go there. In fact, my lord, there is a rules order where Mr. SP Roy had been there and I have been on this side. And my lord were gracious enough to send the matter back to this or issuing.
No, understood, but there is no judgment. In those cases, there is no judgment out there.
Yes, yes.
Here we have a judgment wherein the court categorically makes it clear that you cannot go ahead for a disconnection fund. You can very well go ahead to claim that amount as per the process which is in Envisage Act. The envisaging process is by filing a suit. So therefore, asking him to go out there, does it make any sense for this court? Those matters where there is no judgment passed, then it's a different aspect of the matter. He can very well be asked to go there. But wouldn't it be wrong on the part of this court to do so?
I do not. My lord, if you give me time to understand, I can fix it.
Okay. Issue notice making it returnable on 10th of December 2025. Mr. SP Sharma accepts notice on behalf of the respondent number 1 and 2. Extra copies of the writ petition be furnished to him during the course of the day. So, the grievance of the petitioner herein is that in spite of specific directions being passed by the learned court bench in WPC number
2318.
WPC number 2318 bracket AP oblique 2019. Why is it AP?
Wrongly typed.
2318 oblique 2019. Wherein the respondent authorities have been specifically directed not to take steps for disconnection in terms with section 56 bracket 1 of the Electricity Act 2003 or 13(3). 3. However, granting liberty to the APDCL authorities to take steps for recovery of the supplementary bills as envisaged in the law. The respondent authorities have resorted to coercive measures by incorporating in the bills the area, the amount claimed in the supplementary bills as principal areas, and over and above have also taken recourse to claiming area surcharge and current surcharge. It is the further case of the petitioner that the petitioner was out of compulsion had to pay the current surcharge for the months of July and August, isn't it?
No, July, August, September.
July, August, and September. July and August, not September. July and August 2025.
September also paid.
I don't know, it is not given. Where is that? July and August. And in that regard have also submitted a representation. However, the respondent authorities have not taken into consideration the same. It is under such circumstances, the present writ petition has been filed. Mr. S. P. Sharma, the learned counsel, appearing on behalf of the respondent number 1 and 2, submits that he will obtain instructions on the next stage.
Item 5.
Yes, what is this? Non-payment. When? Dues are from recent dues. What is the date of the due? When did you raise the bills? Huh?
In the period from 1/12/22 to.
It is have it on 23rd of February, filing reply on 16th of February.
I have to finance it. I have to finance it.
Then only we go going.
Supplementary item 45.
Yes, what is this?
There has been a subsequent development. Price of option on that. But may I please position? Do the tender notification. For giving information set up in the user, that's user corporation. That is at page 70. 6 bidders responded. Now, technical. And at page 25, it's a comparative statement. Wherein I, along with other bidders, were rejected. And private respondent numbers 5, 6, and 7, when they only get technical for bidders. We filed the expedition on 5th. 6th, financial bids were supposed to be over. Lordship was pricing up the contract, I would say that now. On 6th, they issued a collision bid. They issued a collision bid. In terms of which they revoked and recalled the technical bid evaluation, and then said that someone had complained for us, and they would do it afresh again, posting it on 9. So at this point, two things come at us. If they had recalled and revoked the thing, they could have very well gone ahead with a fresh number 1. Because our earnest money deposit was refunded on 30th of November. So without earnest money of us being there, if they propose to go ahead, then I am fine with that. But they would take a clause that is at page, Lordship takes up 17 is the tender, and 21, page 21. I'll straight away go to 21. 4.0, minority there. The last one, the word column. Please note. Page 21, 4.0, earnest money, the last one. Please note that.
Where is 4.4? It's
4.4,
4.
that's all. The last line, if I may read. Please note that submission of tender without earnest money would be treated as non-responsive. Now, if they re-evaluate the tender after having given me this development, maybe Saturday, Sunday, because. They've invited me as C. C would be relevant. If I may read the 12th paragraph onwards. It is hereby notified for the information of all prospective bidders that a corrigendum has been issued for the above mentioned tender due to an objection raised by one of the bidders concerning the integrity and transparency of the technical evaluation process conducted by the tender evaluation committee on the on-time e-procurement portal. The previous results and conclusions of the tender evaluation and associated schedule for financial bid opening stand revoked and cancelled. All bidders are mandatorily required to be present in person on 9th.
Who is
December.
paying for Silchar Municipal Board?
I'm appealing on behalf of the board.
It is a corporation.
Of the?
The board,
Okay.
It's a corporation.
You have returned the earnest money deposit.
this- that particular information I do not have.
You have it?
Yes, no, I have instructed.
But I have
30th of
on
November
this
2025.
Where?
This came up now. I-
Where is the document?
Document, no, the instructions I took after I published.
No, not on that. I'm asking you, where is the 30th of November was prior to the filing of the writ petition. So where is the document?
That might not have happened.
Obviously, it will be it's given in your bank statement.
It is there with the client. Last evening, he came to my chambers and said that when once this thing came for re-tendering, I mean, re-evaluation, he said my earnest fund has been returned. So all right, give me the date, I need to apply the honorable court at least.
As per my-
30th of November by RTGS.
RTGS, then why on earth you couldn't get a particular document?
Correct. But once we got these things, now what would be
That
asked?
is, that is.
All the
unhelpful.
persons have been asked to-
I would have very well passed an order to the effect that let them give it by 12 o'clock. That they are reopening, so by tomorrow, let them give the earnest money deposit again. But I can't help you.
But that has been refunded.
I
I'm
don't,
making a statement.
I don't
of
know.
facts.
no, then why on earth you didn't close it? If it has been refunded to you.
We are also challenging the participation of 5 on a specific account. What she takes.
I'm not going to look into all those things. That is for the tendering authority to do.
But if they recall, then they can go for retender because
That
of the
is-
same.
That is
Then my participation, they are not disallowed,
the case.
allow
for
it.
dismissal. This for
regardless
dismissal.
of 74 of the contract.
And the motion stays only, no notice. Not fit for a notice.
What should be kindly appreciate my.
First of all, you have, why on earth you could get hold of this? And your basic point is on the earnest money being refunded, as of now.
Have it at 2, I'll request to get it
Why
at
should
2.
we have it at
No,
2?
no,
We
this-
impose a cost of 10,000, we'll have it at 2 and give it to other people who will be affected.
no, no,
You knew
no,
it
it's not
very well.
good.
No, Mr.
No,
Bonik, Mr. Bonik, you knew it very well that this is your only trump card.
But This came.
No,
after-
this case, you could get hold of this document on Saturday.
Six-
Saturday.
Saturday.
Then, well, today is Monday. Your trump card is that document. Then at 2, if I have it, you will come up and say, how will I arrange this
No.
by tomorrow
That's not
at
difficult.
12
That's not
o'clock?
difficult. The instructions.
Don't come up with all this thing.
They asked it, then they let us go ahead, since they are not objecting to that. I
No,
will-
we can't allow that. They may reject, it, then without earnest money deposit, you knew it, you should have asked for that. That is not your submission. Unless you say you have made a prayer out there. No, bad case, dismiss.
What you may consider this,
I won't,
although,
I won't.
if I will rephrase the submission, what you may consider this part. Page 30, 31 and 32, one for one moment below.
No.
Coming up on that, if the non-submission of that document of refund would be fatal to me, one part, all. Page 30, 31, 32, one line I'll show, one line, page 30.
What is that? 131.
No, only 30.
Yes.
30. This is for respondent number 5, who had submitted the document on which may I read below.
Hmm.
It is hereby authorized to carry out electrical installation work in the state of West Bengal. 31 same, 32 same for respondent 5, 6, 7. I mean, they cannot purchase in Assam. That was our case below.
Mr. Bonik, do you think that I look like the tender evaluation committee?
So I would-
Absolutely
But
no.
now-
If they don't do it, we'll look into it later on as to whether it is fair or unfair. Why should we look into today? They are again going to look into it on 9 as to whether it is there or not. They will look into
The
it.
lordship may have it after that.
Why?
If, because they are not object to my participation.
No, you cannot participate without the EMD. We make it very clear.
Lordship-
Without MEA, you have been returned, so the repetition has become infructuous.
The lordship, we can observe,
Isn't it?
but we had no fault.
No, your fault is there. You have not brought on that document. Mistake. Can't help it.
This is a situation which is full of them.
You knew you on earth, you could get hold of 4 or 5 documents, but you couldn't get hold of the most important document. That my EMD has been returned. Now tell me at 10:30, at 11 o'clock, what order can I pass without that document? No, Mr. Bonik, you think.
If that is the view of.
What the order can I pass out here at 11 o'clock without the document? Give me a good idea. What order whatever you ask, I'll pass that. Tell me. No, tell me.
The way.
You also understand that it is absolutely your fault
So far,
in not getting that document.
so far as.
When you are spoiling his time, he's a busy counsel. He will go to the civil court. You want him to be there at 2 o'clock.
We participate by depositing it too. That's all.
Now, how do I know it has been returned?
They are not even refuting that.
He
It's a
doesn't
matter of
know. It's come up from motion only. That matter.
The lordship at least protects me for some time.
How do I protect you? And when you don't get your trump card? Okay, 12 o'clock, get hold of that document. Mr. Biswas, I'll dispose it of. If he gets the document, because you are going to technically evaluate, you go ahead and evaluate. And only ask them to deposit that year. The EMD, the EMD has been refunded, that not on that, subject to they depositing the EMD by tomorrow. That is it, subject to.
Subject to him furnishing.
Furnishing. If he doesn't, matter over.
For admission item 6.
What is this? Ah.
The respondent criteria site operation has filed their affidavit of operation recently. I mean, there was some time for 55.
Who has filed the affidavit?
ASI corporation. Employees.
They have filed the affidavit on opposition on 2/5/2025, not yesterday. Then why you are making it? Then now you want to file a reply.
No. Because, as per my instruction, the All India Corporation is paying the ESI contribution, so I may be allowed to take on same of the cost.
You are for Oil India.
Lordship, as per lordship,
I'm not going to extend the interim order. Sorry, because of the fact that you filed after 7 months, na, Mr. Smith? That case.
in that case, lordship, I will be allowed to place the case. Because
Okay.
without the interim order. What
No
happened?
interim order. In view of that, yeah, leave the matter on so and so. Where is the interim order, first of all? Interim order, in the interim operation of the impugn order of ESI is kept in abeyance. What is that order of 4/4/2018?
Page 92 and 21.
Page 92 and extra 21. What is that order? Both the parties are remand of the ESI waiving the deposit of money of 50% of the LAs. This is against the pre-deposit.
Lordship,
My goodness, pre-deposit matter is going on for such a long time. Argue?
lordship, what-
Argue? No,
lordship,
no, Mr. Counsel.
I'm placing the case. Lordship.
Yes.
What happened, lordship, in this case, the petitioner approached the ESI court of Dibrugarh, saying the order passed by the DEI corporation at page 55 and 6, lordship, claiming damage upon the corporation.
My goodness. The court has given you 25% and you have come before the court.
What happened, lordship, I'm placing the case, lordship.
No, no.
What happened in this case?
No, Mr. Counsel, I'm going to dismiss this right away.
lordship? I mean, there are-
They ask for, you are actually liable to pay 100. They said at least 50. Now the court gives you 25. And from 2018, you have kept the appeal pending.
I paid some more, lordship. What happened? I paid some more. That's the reason. What happened, lordship? Once the ESI corporation debit the contribution due upon us, there is a provision under section 45AA to approach the appellate authority before the corporation for getting my matter heard. There we have paid 28% to get the matter heard. After that, they have reduced the amount on being shown, document being shown. After that, they limit a interest of rupees 50 lakhs. That also we have paid. Then they limit damages. So against the damages only, we approach the EI court. Upon the damage also, we pledge that this amount for the time being, because this amount is because it's for the court. For that amount, we place it for the court, that 28% may be waived. There's a provision for waiver. That may be
Show me
waived.
that.
75 to B law. So we have already paid more than 50%. Including interest. It's a
No
different
matter
deal.
which is in dispute between the
No matter
principal
which is in dispute between the principal employer and the contractor in respect of any contribution or any other due shall be raised by the principal employer in the employee insurance code unless he has deposited
No.
the 50%.
Normally you have to deposit 50%, and they have exercised the jurisdiction and made it 25. No case.
Because
Mr. Counsel, Mr. Counsel, absolutely, there are plethora judgments of the Supreme Court not to touch with this pre-deposit. Here, they have given you 25%.
It is the contribution, it is the damages. Lordship may-
Whatever damage, no damage, 25%, and for oil, it is not a big deal.
Already, Lordship, we have paid 50 lakhs as interest, Lordship.
It's peanuts.
Lordship.
If it is interest is 50 lakhs, that means whatever may be, it is peanuts. It won't happen. You should have got this matter done.
Lordship, we have paid the.
No, nothing.
Lordship,
Heard Mr. So-and-so. Otherwise, you have merciful judges in the division bench, they may help you out, not me. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. M. Smith appears on behalf of the ESI. The petitioner herein has approached this court challenging an order dated 4/4/2018 passed by the learned labor court,
Yeah.
learned presiding officer, ESI court, Dibrugarh, whereby the learned ESI court had directed the petitioner to deposit 25% of the amount of the total ESI contribution as a pre-deposit. This court duly takes note of section 775 2B of the Employees State Insurance Act 1948. And as the same provision has relevance, the same is reproduced herein under 2B2. From a perusal of the above quoted section, it is made clear, it is seen that no matter which is in dispute between the principal employer and the corporation in respect to any contribution or other dues shall be raised by the principal employer in the employees insurance court unless the principal employer had deposited with the court 50% of the amount due from the principal employer as claimed by the corporation. Further to that, the learned ESI court, the ESI court have also been granted a discretion for reasons to be recorded in writing to waive or reduce the amount to be deposited under the said subsection. In the backdrop of the above, it is seen that the petitioner herein had filed an application under section 75(2)(b) of the Act of 1948, seeking waiver of the deposit of the money of 50% of the alleged amount due from the petitioner. The ground on which the petitioner sought for the waiver is that the petitioner had already deposited an amount of rupees 76,41,563 at the time of filing of the appeal under section 45 AA, capital AA, of the Act of 1948. And further, the petitioner had also deposited an amount of rupees 50 lakhs, 54,640 as interest on the contribution demanded. It is the case of the petitioner that no further amount should be directed. The learned ESI court, taking into account the materials on record, exercised its discretion to waiver 25% out of the 50% pre-deposit. And it is under such circumstances the petitioner has approached this court. This court, having perused the order dated 4/4/2018, do not find that the discretion so exercised by the learned ESI court calls for any interference. More so, there is no perversity or patent illegality in passing of the order dated 4/4/2018. Considering the above, this court does not find this to be a fit case for exercising jurisdiction under Article 2 to 6 of the Constitution. Accordingly, the writ petition stands dismissed with cost of 1 lakh.
No,
No cost.
it's not contribution.
No,
damages.
interim order passed earlier stands vacated.
Item 7.
Yes.
Wait, Peter. Well, the matter relates to payment of contractual dues. Well, we say we have completed 95%. State India affidavit says we have done 84%. Municipal code. Now, my lord, actually what had happened, my lord, after 2020, not a single party has been paid to us.
Huh?
Well, after October 2020, no bill has been paid. And we are also requested to do some additional work. Those are minutes are there were when our thinking was they should make an assessment and pay payment of the bill. Because in the great, financial hardship.
So why the matter has become so big? I mean, so there's a non-payment of dues matter.
Meetings are there. There are one additional affidavit and otherwise you know, wait petition.
But where is the stand of the respondent?
Yes. Page 123, below.
Has not completed 100% of the whole project till date, and that he has only completed further has claimed and he is yet to receive area that exceeds his estimate value. Then release central share so and so total amount. How much is he entitled to?
40, total is 14 crore not plus we have done additional work.
No, that we can't touch it here. But Mr. Bigogoi, how much he is entitled to?
1424.
So the amount has not been admitted.
No, but you say that he has completed 85% of the work. That's at paragraph J,
Yeah.
page 123. So how much is he entitled to as per deal? Or is it the case that there is a penalty clause and all these aspects comes into being? But there is no statement out there.
There is nothing.
Whether since the road project was delayed, its cost has increased as the material cost has increased day to day, has essentially sabotaged the project, ultimately causing inconvenience to the people of Lucknow. The opponent further begs to submit that the government has released the following funds amounting out of which a total sanction amount to the land of so and so the project. So and board has received the fund of environment. The work is not yet complete.
So we after done, madam, yes, thereafter 84% according to our October 2022. Then the page to March 23, the last extension was given on 31st Jan.
It's a lot, so kindly have a look at page number 98. It's part of the 98. It's an additional affidavit.
Yes.
Please come to page 99. Following resolutions are taken up by PIC after fair discussion in the meeting. PIC has allowed extension of time to the contractor up to 31st of October to complete the project. Committee employed exhibition to constitute a joint technical committee with exhibition because the technical person of municipal board, technical person of the office of the town and traffic and district welfare. The joint committee will prepare estimates regarding additional work done by the contractor beyond the DPR for NCLS. So I have already done. The committee resolved that excess fund for payment of bill against the additional work done by will be borne by own fund of the Lakhimpur Municipal Board with due consultation and group meeting based on estimates suggested, submitted by Joint Ethical Committee as mentioned in resolution number. Deputy Commissioner Goalpara will take all necessary steps to release the remaining government sanctioned fund and to make payment to the contractor against the completed work. The committee charges consequently go repairing of. And there is a clause below, every month they're supposed to pay a running bill. If they don't pay, how do I progress? I cannot put in money every time from my pocket.
That will be a breach of contract. 48 will come in.
That's true, sir. At least to the extent of their own ambition, they should make the payment, rest will.
But there are questions out there. If there is a default, these are questions which can be decided by the civil
That is
court.
not the stand of the department.
Additional affidavit, I'm appearing for the board, not for the document.
But he has not said anything else. What is being mentioned out there?
Additional work.
What is being mentioned, you have a copy of the additional affidavit? Just give it to him. He has not mentioned anything out there in the additional affidavit. Kindly come to annexure Roman 14. This is what is there in the following resolutions. These are the resolutions. 107. The PIC has allowed extension of the contractor year to complete the so and so, and this is what these are the various resolutions. So this is nothing to your deputy commissioner. If this is done under the chairmanship of the deputy commissioner, and yep, you are paying for whom?
The board.
Okay, so the board is very much a party out
Yes.
there. Is there? It is given out there. The chairman, he's number 4. Copy to the chairman, Lakhimpur Municipal Board.
The lawsuit is similar to the jurisdiction number 3, that page 107. And then there are some amount. Committee resolved that the excess fund for payment of bills against the additional work done by the contractor will be borne by own fund of the Lakhimpur
Board, based on the estimate submitted by the joint technical as mentioned in resolution number 2. So under such circumstances, what is there or what is not there is to be decided by you, whatever amount it is there.
Yes.
But Mr. Chaudhary, I have a worry out here because if there is not done properly and all, why this is not a case of a civil suit? Why should this court look into
So
it?
in that
Because
case, in
the
that
problem-
case, they can quantify the amount below, they can take the instruction.
But Mr. Chaudhary, you see one big problem. If the matter is there, if I pass an order for direct verification and making payment, then if they verify and give up with some amount, then at the end of the day, you have to go to the civil court. And I am bound to say, what is the verification?
And there are 2-3 judgments of the Supreme Court in scenario like this. Possible not relegate me to civil court, that they work for 2012, 13. Well, 9 years
No, your work has been extended
to up to 22.
22, so you have the time. So this period will be duly taken care of. From 2022, I will they take out the limitation and give it to you on the basis that you are doing it diligently.
Before that, if my London friend is directed to update the instruction, according to them, what is this 84%?
And they will come up with this thing that you have not worked.
If they say, let them come up with the figure, let us see. If not, then we'll also relegate us.
I can come up.
Because this is not, therefore I ask, this is a matter of a particular nature. Normally, this is the course of pass orders I pass. Why should I ask them? Because the fact remains that if you are entitled to certain amount, very well. I think this is a matter which requires to be done before the civil court, not before this court. And you see, I understand I'm taking up this non-payment of dues where a verification is given and I know what is going to come, Mr. Chaudhary. At the end of the day, you will be losing on 6 or 8 months. And at the end, because you will never be satisfied with that amount. And once they verify and they will come up again, the file contempt and all, this will go on. It is certain matters, it is very difficult. The only way out is by way of a civil suit.
Again, civil.
File a summary suit. These are admitted demands of the. It is a different thing that he has difficulty in going to Lokhipur.
Let me have the instruction. Let he also let Tata come on 18 million. Let Lanet also have the, we also have the instruction. I think my landed friend also has the instruction informing him. Let us see.
No, verification, if you want, I can pass an order of verification, but at the end you will be in trouble. But you want, I can very well pass.
I think
You
that
verify and make the payment, including I give you the right also to penalty and all. I give you the right to invoke the penalty clause because I have to give him that.
whatever contractual that, the contract protects me also. It's not that
The contract protects you, but the non-completion of the contract also protects him.
For what reason? That is to be seen, Mila.
What
If I
we-
don't, there is a particular clause.
No. Therefore, I am not going to decide whether they want to impose the penalty clause, but liberty given to them to initiate also the penalty clause while carrying out the verification.
That they can do of their own.
No. While carrying out the verification, if they come up with a particular figure, 84%, this amount of money he is entitled to. But for non-completion, we are entitled to 1% or 2% of the work. How do you take care of that?
Your lordship experience on the other side and this side. Have we ever come across a big contractor complaining that I have not received the bill? None. It's all the small time contractor who has to come. Why? If there is a shortage of fund, there's shortage of fund for everybody. But every time they work, small time people are before your lord.
But ma'am,
Persons who are
Mr.
constructing this effort,
Mr. Chaudhary, see, there are few contractors, like one is Mr. Musliman, one is GR Pasa. They have lots of matters, and I can't say, taking into account the magnitude of matters they have, they can be said to be small time. First, I used to call Mr. Diganta Das to be the standing counsel of this petition. Now he has shifted to you. Now there are another one is Vana Construction. In soil, these are to be small time contractors. The small time contractors are different. But at the end of the day, this is what is going to happen. I have no problem in passing an order. At the end of the day, you will be more in trouble.
let them verify and make it.
Okay, I'll dispose it off.
Yeah.
You at the time of verification, you also look into if there is any breach. What will be the heard Mr. K. N. Chaudhary, the learned senior counsel, assisted by so and so appearing on behalf of the petitioner. Mr. B. Gogoi, the learned standing counsel, learned counsel who represents the respondent numbers 3, 4, 5, and 6. Mr. K. Gogoi appears on behalf of the respondent number 1 and 2. The petitioner herein has approached this court seeking a writ in the nature of mandamus, thereby directing the respondent authorities to make payment of an amount of rupees 4 lakh crores 59 lakhs 01594.92 to the petitioner through the RA bill in respect of the works already committed. The case of the petitioner, as could be seen from the materials on record, is that a contract work was that the respondent respondent Lokhipur Town Committee had entered into a contract with the petitioner for construction of 4 numbers of town roads, including RCC culverts and drainage at Lokhipur town, under NLCPR for the year 2012-13 at a total amount of rupees 14, 16, 30, 344. Pursuant to the entering into the contract, it is the case of the petitioner that petitioner had completed how much? 95% of the work. However, in spite of the bills being submitted from time to time, the petitioner had not been released the bills since 2022. 2020, October 2020, and thereby amounting to an amount of rupees 459,01,594.92. Full stop. In that regard, a petitioner had also submitted a representation on 29/1/2022. However, as the said representation remained unconsidered, the petitioner has therefore approached this court by filing the writ petition. It is seen that the respondents have filed their affidavit in opposition, wherein the respondent Lakhimpur Municipal Municipal Board have filed an affidavit in opposition, wherein it is categorically stated that the project in question was supposed to be completed within 18 months, and the contractor was handed over the site on 15/5/2015. But the contractor delayed in starting the work. It is further mentioned that the executive officer Lakhimpur Town Committee had issued letters to the contractor for providing an explanation in delaying to start the work after the site was handed over to the contractor. Further to that, it is mentioned that the contractor only started the work on 8/10/2015. It is also alleged in the said affidavit in opposition that there was slow progress of the work by the contractor, for which various notices were issued to speed up the work. At paragraph, in the said affidavit in opposition, there is also allegation that the work done by the petitioner were of poor quality, and notices were issued to the petitioner for rectifying 6 spots with earth filling, sand gravel, blacktopping. It is also alleged that the petitioner had been granted 10 extensions from time to time, and the last extension expired on 31/10/2022. It is also stated in more particularly in paragraph number 3J that the petitioner had only completed 84% of the project work, and the claim which the petitioner have made exceeds even the estimated value. Pursuant to the filing of the affidavit in opposition, the petitioner had also filed an affidavit in reply.
Page 124. It is a central funded problem. Page 124.
I'll take it as your submission. I have filed an affidavit in reply, wherein the petitioner admitted that the work in question could not be completed, but the reason for non-completion was on account of the fault of the respondent, Lakhimpur Municipal Board. This court on the basis of the pleadings, have also heard the learned counsels appearing on behalf of the parties. Mr. K. N. Chaudhary, the learned senior counsel appearing on behalf of the petitioner, submitted that the petitioner have carried out the work to the extent of 95%, and as such, the petitioner is entitled to the amount as claimed to the tune of rupees so and so 4 crores into their assailant, which the respondent authorities have not paid. He further submitted that the stand so taken now by the Lakhimpur Municipal Board is contrary to their stand in the resolution adopted on 8/8/2022 in the minutes of the PIC meeting for discussion about the progress of the work in question. He therefore submitted that the respondent authorities were duty bound to carry out the necessary verification and make payment to the petitioner against the running account bills, which the respondents have not done so since October 2020 to the prejudice of the petitioner. Mr. B. Gogoi, the learned counsel appearing on behalf of the Lakhimpur Municipal Board, however, submitted that the petitioner had breached the terms of the contract in as much as the contract period was 18 months. He further submitted that if the work in question was started by the petitioner on 8/10/2015, and till date the work have not yet been completed to the prejudice of the public of the Lakhimpur Municipal Board. He therefore submitted, in addition to that, the learned counsel appearing on behalf of the respondent of the Lakhimpur Municipal Board further submitted that this is a project where it is partly funded by the central government, which is duly mentioned in the affidavit in opposition, and as such, without the central government being made a party, the petitioner cannot succeed. Because this court have heard the learned counsels appearing on behalf of the parties. From the materials on record, it's clearly seen that there are disputes as to whether the petitioner disputes as regards the entitlement of the petitioner. On one hand, the petitioner claims that the petitioner is entitled to the amount of rupees so and so pertaining to the work completed by the petitioner. On the other hand, the respondent authorities allege that the petitioner have breached the terms of the contract, and as such, and thereby causing great prejudice to the public in question. In addition to that, there is also dispute as to how much amount of work have been completed by the petitioner. Considering the above, it is therefore the opinion of this court that this court is not in a position to direct the respondent authorities to pay the amount of rupees so and so to the petitioner as has been sought for in the relief. Because be that as it may, it is, however, also the opinion of this court that if the petitioner have duly completed certain works, the respondent authorities and have submitted a representation, it is the bounden duty of the respondent authorities also to inform the petitioner as regards the fate of as regards the outcome of the claim so made by the petitioner. It is also being alleged that the petitioner have not received any amount since the month of October 2020. Because under such circumstances, it is therefore the opinion of this court that certain directions can be passed for carrying out necessary verification as regards the petitioner's entitlement and to make certain payments if the petitioner is found to be entitled as per the provisions of the contract entered into by and between the petitioner and the respondent municipal board. Accordingly, the petition therefore stands disposed of with the following observations and directions. First, the respondent authorities, more particularly the Lakhimpur Municipal Board, shall verify as to whether the petitioner is entitled to any amount in respect to the contract in question while carrying out the said, verification, the respondent authorities can also take into account as to whether they take into account that any breach committed by the petitioner and the resultant effect as per the terms and conditions of the contract. First, the said verification be completed within a period of 6 months from the date the petitioner has submits this representation to the respondent number 4. So it is further observed that if upon verification being conducted in the manner aforesaid, if it is found that the petitioner is entitled to any amount, the said amount be paid to the petitioner within the said time frame. So it is further observed that in the circumstance there are any disputes on the verification amount, the petitioner can take resort to are disputes. The remedy of the petitioner lies before the civil court. Better off you should have got that order, which I say. You're not going to get a single penny. You should have got that order that you go and file a civil suit. It would have been much easier. They will come up, they may ask you money. I know that I've dealt with so many matters, so I know how it is going. At the end of the day, you are in more trouble with this order which you got. Anyways. What is this?
I was working, so I did not got it, but it's like later upon there.
10,000 cost.
No,
No, 10,000. Upon you. No, either you take the blame on yourself or take the blame on the respondent. So respondent authority's blame is not there, blame is on you. So up 10,000 upon you. No, madam, the question doesn't arise. We fix the matter today, taking into account your submission as to whether in pursuance to the award passed by the learned arbitrator, you are required to refund the security deposit. But because of these type of prayers, what happens is, you see, do you see my list today? It has gone to 71 because of this type of prayers.
Tomorrow, definitely I'll take that.
How will you, tomorrow, don't you think there are other matters there
Yes,
for this court?
I apologize for that.
Then-
No, I learned that. I have already informed that.
Are you entitled to interest?
As per the contract act, or the contract that is there, they say that it is not carrying it. But
Okay, under 226, we impose the interest. I know. No, we have it, adjourn Sinai and say that the interest will accumulate at 80%. No, absolutely not. No, this is not done. Because of you, this has happened.
Yes, madam.
It is unfortunate. It is unfortunate that in spite of seeking it is unfortunate that in spite of this court providing an opportunity to the respondent authorities to provide instructions by an order dated 26/11/2025. Till date, the respondent authorities have not placed any instructions to the effect that instructions as sought for by the order dated 26/11/2025. Now, it is unfortunate that the respondent authorities have not produced the instructions in spite of the order dated 26/11/2025. To list the manner. On 6th of April 2026, in the meantime, it is observed that the delay having been caused at the instance of the respondents, the petitioner would be entitled to the interest if within this period, within 30 days from today, the petitioner is not refunded the security deposit. 30 days I've given you. You deposit, good. Otherwise, interest.
Okay, okay.
And
What happened? So,
We want to propose my vote. There is another petition by the same petitioner, wherein the actual distance was 13.4 kilometers and he has traveled 11 kilometers. That is. So, appropriate and appropriate at the same time, where he wanted it should not be reduced, the rate should not be reduced. So from 350 went to 95, there the distance was mentioned 11 kilometer, but he has traveled 13 kilometers. There he want that the access amount. Because of the access kilometer. What I want to propose, madam, that both the matter be taken up together. Excellent. Same case is a different matter, that is a different matter. How will argue that there is a comparison? There he has taken other step.
which writ petition is pending?
My lord, the petition number 7637 of 2018
It's pending.
is pending.
Let us get that. This matter along with WBC number
7637 of 2018.
on 21,
Before taking that.
what before vacation, no time. Okay. On 16th,
1617 18. Monday,
ask somebody else to appear.
minus 15 madam, 16 national. Out of station. So. Fixed that.
On 15/12/2000.
where
What is water filter? What water filter is this? Mr. Council, what water filter did you? We supplied what? You supplied water filter. What make of water filter did you supply? Huh? What make of the water filter did you supply? Umbrella, you could say very well say Mohendra Datta. But what about the water filter? Hmm? Huh? What make? You produce the MRP at which you have purchased? Produce from the manufacturer, what is the MRP? Then you can find it out. Your problem is what is there, you are not in a position to find out 2018. I give him 15 days, he will produce the make of the water filter because nothing is given. What water filter did you submit? Umbrella, it is okay. You have given Mohendra Datta. That can be ascertained from the company, what was in 2018. But as regards the water filter, you have to ask for that. Now, they have come up now with that thing that they have got it from somebody. So at that point of time, it is not so much. It is now 2,995. You have quoted 2,750. 200 rupees less. So at that point of time, it must have been less. Now 7 years, 200 rupees have increased. But tell me, if that be so, if you are not in a position to find out what is the water filter's rate, what is your basis of your inquiry report? What is your basis of your inquiry report? Because you see, after Kerber, it is seen that 3 different locations delivering the items were asked to be done by so and so. Young and it was asked to supply the items to so and so Iman. The undersigned conducted spot verification on Iman. During verification, it is found that no APR was maintained by the Iman. In their regard, submitted before the undersigned that given some time the APR can be prepared. Since APR is not available to further verify to whom actually those water supply items were distributed by the PDA so and so, supplied by so and so could not be made from the end. Resulting payment cannot be determined unless complete APR are thoroughly examined. How can you raise all these issues? He has supplied, you have to pay.
That's why I should perhaps, as per the session I have submit the option. So then maybe, I mean, like that, they maybe give a chance to certain the rate. Because
What is there to ascertain the rates? Your problem is not the rates. Your problem is that you have to prepare the APRs. Now the fact remains that it has gone to it was duly served upon, submitted to the director PNRD, and the project director DRDA. And how he distributed is, how is he concerned? Was it his responsibility? Enquiry report is not satisfactory. You pay within 6 months, whatever is due. Now, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. N.R. Sharma appears on behalf of the BTC. The petitioner herein has approached this court seeking a direction upon the respondent authorities to pay the bill amount of rupees 99,98,935 against supply of 118 pieces of water filter which stand bracket 25 liters capacity and Mahendra Datta umbrellas bracket 5881 pieces for ladies, 5618 pieces for gents. Pursuant to the approval order number BTC bracket oblique RD bracket purchase dash 32 oblique 2017 dash 33 dated 21/11/2018 and the intimation letter number DPRD oblique BTC oblique bracket SOPD bracket close dash 5 oblique 2017 oblique 256 dated 4/12/2018 under the signature of the Director Panchayat and Rural Development BTC Kokrajhar, along with interest at the rate of 12% per annum. Footstop. This court have duly perused the materials on record, including the various work orders on the basis of which the petitioner claims the amount as stated in the writ petition. This court have also perused the affidavit filed by the respondent number 226, wherein affidavit filed by respondent number 226 on 2nd of February in December 2024, wherein it has been categorically mentioned by the Principal Secretary of the BTC that the contractual bills claimed by the petitioner shall be completed, that the verification in respect to the contractual bills claimed by the petitioner shall be completed within 2 months from the passing of the order dated 18/11/2024. Full. It is further seen that there is another additional affidavit in opposition which has been filed, wherein the Principal Secretary BTC have raised concerns as regards the working of the BTC and the flouting of the budgetary provisions by the BTAD authority in issuance of various contractual works. Be that as it may, it is mentioned, be that as it may, in the said additional affidavit in opposition, an inquiry report have been submitted dated 26/2/2025, made by the have been enclosed dated 26/2/2025, issued by the made by the Joint Secretary cum Inquiry Officer BTC, wherein it is being mentioned that on account of non-preparation of the what is APR? APR is no idea. Non-preparation of the APRs, comma. The payment to which the petitioner is entitled to could not be determined. It was also mentioned that the market rates in actual against the quoted items also required to be verified prior to making payment to the petitioner. The said report, inquiry report, is dated 26/2/2025. When the matter was taken up by this court on 22/10/2025, this court inquired with the learned counsel appearing on behalf of the BTC as to what further actions have been taken in furtherance to the inquiry report dated 26/2/2025 enclosed as Annexure 1 to the additional affidavit in opposition filed by the respondent number 226. Full stop. In spite of various opportunities being granted from time to time, today, and pursuant to various opportunities granted by this court from time to time, today, the learned standing counsel of the BTC has placed before this court a set of instructions dated 3rd of December 2025, which is kept on record and marked with the letter X. From a perusal of the said instructions, it is seen that the inquiry officer could not ascertain the market rate in spite of a passage of 10 months. Be that as it may, it is very pertinent to take note of that in the said instruction, a communication of the Director Panchayat and Rural Development BTC Kokrajhar have been forwarded to the Secretary PNRD on 3rd of December 2025, wherein the present rate of the water filters which stand have been mentioned as rupees 2,995 per piece. The materials on record. This court have heard the learned counsels appearing on behalf of the parties and have perused the materials on record. From the materials on record, it is clear that the petitioner herein was issued the work orders in question. And in pursuance to that, it is also seen that the petitioner had supplied the quantity in question. The grievance of the petitioner that in spite of the supply being made, the respondent authorities have not made the payment. On the other hand, the respondent authorities have, instead of answering to the, instead of carrying out necessary verification, all this while have resorted to blame the earlier BTAD dispensation. So, be that as it may, the fact remains that the petitioner have duly made the supply. So, under such circumstances, it is therefore the opinion of this court that as the petitioner have made the supply, the respondent herein are required to make payment to the petitioner. So consequently, the instant with petition therefore stands disposed of with the following observations and directions. The respondent authorities are directed to carry out the verification as to what amount the petitioner is entitled to pursuant to the supply so made by the petitioner. To ascertain the amount which the petitioner has claimed the petitioner is directed to furnish, to place before whom? Before the director. Director, you don't believe. Whom should we give it? To the secretary. To the secretary BTC. To the secretary BTC. The details at which the petitioner that the rates, the prevailing rates of the water filters as well as the umbrellas which were supplied by the petitioner during that relevant period of time. The respondent authorities, on the basis of the said materials being placed, said carry out the necessary verification as regards the entitlement of the petitioner. And on the basis of such entitlement, and on the basis of such verification, if it is found that the petitioner is entitled to an amount, the said amount be paid to the petitioner. The entire exercise be completed within a period of 6 months from the date a certified copy of the present order along with the rates at which the petitioner supplied the the prevailing rates of the water features and the umbrellas in question is furnished to the Secretary BTC.
Standing item 45. But one thing, that's okay, by the record, it's okay to correct. Now, only one thing remains. If not, you kindly appreciate this. If I don't kindly appreciate this. We participate in the tender process with the belief that it will be transparent and fair, not arbitrary bias or offside. Once a competitive statement is drawn, rightly or wrongly, I'm out. And rightly or wrongly, 3 persons, the private respondents are in. The moment we challenge this in this honorable court, they come up with a correction and they will take it out again afresh without indicating that we may submit earnest money later, or it is waived, or for the time being, that's not required.
Mr. Bonik, did you hear what order I said I will pass? If you want anything more, I can issue a notice and we will hear you sometime in leisurely, just before the July vacations next year. In the meantime, let them complete the work with all other people. No stay, nothing.
By bankrupt your law.
Of course.
By bankrupt.
So kindly come to the point. We are not concerned. Let them take a decision again. And then why do you close your door? Your door, not the door of your client. Don't, no more, no more, no more. This is the order which I said I will pass, nothing more.
So we need a paper then, informing analyst from the honorable court, that the request to be present in person. That perhaps will take up with the authorities, is separate from number in that's between them.
What?
Expert who's representing me is separate from number problems. So to be physically present, that's represented, absolutely. You take up with the authorities. Yeah,
Regarding what?
they have, by the calling them, they made a thing that you have to be present in person. From here to Silchar, he's having a number problem, so he may not be happening, that will take up with the authorities.
Take a car. It doesn't take the good roads, go there. Why should we go into all these things? You don't have a car also and we're bidding for a cremation. At least leave the cremation out of tender. Heard Mr. S. Bonik, the learned counsel, appearing on behalf of the petitioner. Mr. A. Biswas. Who appears for housing and urban? Yeah, Mr. King, who appears on behalf of the respondent number 1. Mr. S. Biswas appears on behalf of the respondent number 2, 3, and 4.
Yes, sir.
Who's taking into account the order which this court proposes to pass, this court dispenses with the notice upon the respondent numbers 5 to 8. The petitioner herein had approached this court challenging the disqualification of the petitioner, the technical disqualification of the petitioner by the respondent authorities in its meeting held on 29/11/2025, and the further qualification of the respondent numbers 5, 6, and 7. Full stop. The materials on record reveal that the respondent, Silchar Municipal Board, had issued a notice inviting tender dated 6/11/2025 for drawing, designing, inviting bids from bidders, eligible bidders for drawing, designing, supply, installation, testing, and commissioning of twin electric furnace with pollution control unit and 30-meter height chimney, including 15 days trial run and 1 year operation for cremation of human dead bodies at Silchar burning ground under the Silchar Municipal Corporation under NCAP bracket 2024-25. The petitioner, along with various other bidders, duly participated in pursuance to the said notice inviting bid. First, it is pertinent to mention that the bids sought for were of two stages. One is the financial technical bid and the other is the financial bid. First, it is the case of the petitioner that the petitioner's bid was rejected on 29/11/2025 on the ground of electrical license submitted of DD Metal Corporation. First, on the other hand, the respondent number 5, 6, and 7 were held to be qualified for the financial bid. First, being aggrieved, the petitioner therefore approached this court. It is further pertinent to take note of that pursuant to the rejection of the petitioner's technical bid, the earnest money deposit which the petitioner submitted in pursuance to clause 4.0 of the no bid document was refunded to the petitioner on 30/11/2025. Next, being aggrieved by the disqualification of the petitioner in its technical bid and the qualification of the respondent numbers 5, 6, and 7 for evaluation of the financial bid, the petitioner approached this court by filing the writ petition on 6/12/2025. On 5/12/2025. First, it is very relevant to take note of that pursuant to the filing of the instant writ petition, a decision was taken by the Silchar Municipal Board for administrative reasons to revoke the technical evaluation and to again evaluate the technical bid opening, technical bid. In that regard, a corrigendum was issued on 5/12/2025 itself, and due intimations were given to all concerned by in the e-portal of the Assam tenders on 6/12/2025. Mr. S. Koenig, the learned counsel, submitted that as the respondent authorities are again going to re-evaluate the technical bid, the petitioner bid also is required to be re-evaluated. And in as much as the evaluation which was done by which the petitioner was petitioner's bid was technically rejected. Technical bid was rejected, have become non-est. The Learned Counsel further submitted that in view of clause 4.0 of the bid document, the petitioner having the petitioner's bid having already been earnest money deposit having already been refunded, directions be issued upon the respondent authorities to consider the technical bid of the petitioner without the earnest money deposit and with a further on an undertaking given by the petitioner to submit the earnest money deposit within a couple of days.
Wait for me.
Huh? Within a couple. Mr. A. Biswas, the Learned Counsel, appearing on behalf of the Silchar Municipal Board, submitted that the instant with petition has already become infructuous, taking into account that the decision dated 29/11/2025 by which the petitioner's technical bid was rejected have already been withdrawn. He, however, submitted that it is the mandate of clause 4.0 that the earnest money deposit has to be a part of the bid document to be submitted. He further submitted that in view of the fact that the petitioner's bid earnest money deposit was returned on 30/11/2025, the petitioner can very well submit a fresh demand draft of the said amount as mentioned in clause 4.0 of the bid document. First, this would have it is relevant to take note of that during the hearing of the instant proceedings, Mr. Esponik had submitted before this court the revocation corrigendum, as well as the various details pertaining to the changes made in the portal pertaining to the tender in question. These documents are collectively kept on record and marked with the letter X. It is further seen that during the course of the hearing, Mr. Esponing had also placed before this court the intimation given by the respondent, Silchar Municipal Board, the reason for holding that the petitioner's bid was technically not competent, as well as also placed the certificate issued by the State Bank of India, wherein it is seen that the amount of rupees 6,99,868, which was the EMD amount, was refunded by the respondent Silchar Municipal Board. These two documents are kept on record and marked with the letter Y. From a perusal of the above development which took place, it therefore appears that the respondent Silchar Municipal Board have withdrawn the evaluation of the technical bids which were carried out on 29/11/2025. Under such circumstances, the petitioner, whose technical bid was rejected and have withdrawn. Further to that, it is also seen from the document kept on record and marked with the letter X that there is a notification dated 6/12/2025 in the portal, wherein it is mentioned that the tender in question would be now at the stage of technical opening. Considering the above, therefore, it is apparent that the petitioner's bid, therefore, have not yet been evaluated. It is also relevant to take note of that in the meantime, the petitioner who has duly submitted the earnest money deposit of the amount of rupees 6 lakhs into the asset have been refunded back to the petitioner on 30/11/2025. Because this court also cannot this court also duly takes note of the submission of Mr. A. Biswas, the learned counsel appearing on behalf of the Silchar Municipal Board, wherein he submits that the petitioner can be granted, the petitioner can be granted. In view of the refunding of the earnest money deposit on the basis of rejection of a technical bid of the petitioner which no longer exists, it is the opinion of this court that the petitioner should be granted an additional opportunity for submitting the EMD to the tune of rupees so and so. Accordingly, the instant writ petition therefore stands disposed of with the following observations and directions. The petitioner's technical bid be again considered along with other bids so submitted by the bidders, subject to the petitioner submitting a demand draft from a nationalized bank of an amount of rupees so and so by 12 p.m. 12 p.m. Right? Obviously, it can't go beyond that. Don't expect this much. By 12 p.m. on 9/12/2025. Upon submission of the said bid, this court have not decided anything as regards the technical competence of the respondent number 5, 6, and 7, though there is a specific challenge. Taking into account that the respondent authority would again re-evaluate as per its revocation agenda, as well as the intimation dated 6/12/2025, published in the notified in the e-portal of the Assam tenders. Number 3, it is observed that in the circumstance, the technical evaluation is being carried out, holding the respondent number 5, 6, and 7 to be technically qualified, the present order shall not preclude or prejudice the petitioner in again approaching this court. Anything more?
It's under corporation.
What?
It's corporation.
You have made board or corporation?
Corporation.
Corporation.
Item 11.
And Mr. Biswas, you intimate your people. Mr. A. Biswas, who represents the Silchar Municipal Corporation, shall intimate his client about the present order. Forthwith, a registry shall provide the copy a copy of this order to Mr. A. Biswas during the course of the day. You provide immediately.
Item 11.
You have filed?
My lord. Now, both are on the petitioner's side now. The-
If it is petitioner's land,
not-
it's okay. Then wouldn't that license agreement act won't come into play?
Right, if we take instructions on this, there be two possibilities. But that licensing rules will of course come in if there is a compensation amount to be paid. But if there is a possibility of removing the poles and putting somewhere else, but that would also get the grievance. I can just get instructions on the line. Lordship permits me.
It has been submitted by Ms. Yuda, the learned additional senior government advocate, that the affidavit has been filed on behalf of the respondent. Respondent number 2. It is also mentioned that in the said affidavit, comma, the respondent number 2 have categorically mentioned that the poles, the electric poles are within the area of the electric poles have been erected over the land of the petitioners. The said affidavit, however, is not on record. The respondent, the registry is directed to bring on record the said affidavit. Lists the matter on 21 1 2026. In the meantime, comma, Mr. B. Chaudhary, the learned counsel appearing on behalf of the APDCL, shall obtain instructions as to whether the petitioner herein, as to what steps the respondent authorities would take in view of the stand taken by the respondent number 2. But I think you should go for that. In view of that, why are they not going for that license thing? Because that day I passed one order.
Yes.
Where I have mentioned out there following that there is a judgment of the Supreme Court in 2022, 15 SCC page 1, wherein it says, you see the you can't have it on the valuation of the land. If you see section rule 13 or rule 15, it says to the loss suffered. The loss suffered will include the valuation of land, anything else by which he has been taken. So I say that the parameters of 26 and 28 of the Assam, the right to fair compensation. This is done in terms with the judgment of the Supreme Court in the case of NHI cases, wherein there has been question arose that whether the compensation parameter will be in terms with 3G of the year. The Supreme Court said no, not only 3G, but also 26 and 28. So taking into account that, I have put this.
The order is not uploaded yet, that not at the, that order is not uploaded yet.
Oh, it should have been uploaded. Have a look at it. Uploaded.
Well. Last order contains 10 matter.
I've asked you to file an affidavit. What is this later part of today means? When? What is your stand? Okay, let us have it. Bring that affidavit. Once you file it, you get a requisition, we take it and finish it off. What? It was supposed to be filed. Okay, we call the additional chief engineer. Okay, list the matter. No, there's a direction passed by this court to file it. You have not filed it. Yes, better.
So the thing as per order, it is 17/11/2025, the respondent number 4 is supposed to file the affidavit. And respondent number 2 affidavit. will-
Affidavit filed by respondent number 4.
4 I have. 4 not filed.
Who filed?
4 has filed. Affidavit filed by respondent number 4 on 27/11. Yes, affidavit filed as per order dated 17/11 by respondent number 4. Additional Chief District Commissioner South Salman. Along with certain area for expenses, the pending liabilities of the court case Dilip Botra and so are so Iman. Amount pending like as further that original so. It is further mentioned the Xerox copies of the Iman and they are submitted to the Iman. Iman's letter and content of the deponent is and they had yes, received from the letter was sent to the commissioner regarding the petition. So, so district commissioner has filed. What about the PNRD?
PND when just now
Yes, when did you file?
today.
You have also filed today. Where is the copy? To me, what is your step?
Terastic minute last part. What another process?
Again, the same thing. You are back to square one.
Till now,
No, he said, the district commissioner says that we have given you on a particular date.
paragraph 5 in our page number 9.
Yes. Therefore, considering the same, this commissioner once again issued letter to the Iman as so and so, hereby again requested to depute an EI along with certified bills. Now, the stand of the DC is very clear. Then look here, we have given you the original bill sometime. If they want, you want a deputation, they will give a deputation of a person. But the question is, you say the bills are not available, or you want the duplicate bills to be submitted by a petitioner. Tell him that can be arranged. Receiving they will do because they have duly admitted this amount. Huh? But they say that they have duly submitted.
The letter of submission has there.
Is mentioned herein the deponent has filed the additional EI so and so was submitted Iman by the office dated on Iman and Iman. 5/1/2018. Further, the deponent begs to submit that all bills, vouchers and other for the Panchayat area were already submitted to the office of the Commissioner Panchayat on 5/1/2018. Where is he going to bring the DC? You lost the files. Now you are going not to pay. They are saying it. Therefore, I ask you, both of you talk amongst yourself. You are not talking. No, after this stand which is being taken, I don't understand. Either both of you break your fixed deposits, both of you, the commissioner and the DC, half up and pay it to him. None. Better off, half up. Both of you take the responsibility. But you can't say that here, because you have in the transaction, you have lost the files. You can't say that petitioner is deprived. Take a secondary copy. Accept the secondary copy then. Because they say the materials have been duly supplied. Your only thing is that you need the original receipts. Now, how will you get the original receipts if it has been already provided by the DC?
Can this be this, paragraph 5? The letter dated 30th with the aesthetic officer,
But they could not substantiate the same as there was no available records available regarding receiving of these so and so as per the letter dated so and so.
Considering the state that commissioner once a day is letter to the district officer. Letter to one, wherever again request them to deputy the officers with certified bills persons to arrive at the conclusion regarding the discrepancy as well as to submit the proper documentation of declaration.
So they now say that certified bills vouchers. So if you get certified bills and vouchers, that would be okay. So they will certify it.
How much
Understood, but whatever may be, you must be having an additional copy.
Hard copy.
So get it certified then. The fact
Yes,
that
sir.
they duly admit that this has been the supply. Now you have received it. You say that you have not received it. So whether the certified bills or vouchers would be enough, if it is certified by them. You get your instructions on that specifically. It is pursuant to the order passed by this court on 17/11/2025, it is seen both the respondent number 2 as well as the respondent number 4 have filed their additional affidavits. It appears therefore from the stand taken by the respondent number 2 that the bills as well, the original bills as well as the receipts have not been received by the Commissioner PNRD, by the Commissionerate of the PNRD. Though the respondent number 4 categorically mentions that on 5/1/2018, the same was duly furnished to the Commissionerate PNRD. The fact that the petitioner is entitled to the amount is not in dispute. However, on account of certain formalities to be carried out for disbursing, which includes the bills as well as the receipts, this court inquired with the learned counsels appearing on behalf of respondent number 2 and respondent number 4 as to whether the respondent number 2, whether providing the certified copies of the bills, vouchers, and certified copy of the receipts of the materials would suffice for the purpose of releasing the payments to the petitioner. Both the counsels appearing on behalf of the respondent number 2 and 4 submits that they would obtain instructions. So considering the above is the matter on 19th of January 2026.
What?
Got the money? You have filed affidavit. What is your stand?
Yes.
Show me that. You have a copy of it, Mr. Gugoi? These are old matters, therefore it becomes very difficult. The amount of security in some paragraphs, whereas it is mentioned as the petition thus suffers from it, shall not be able to be in place.
And my lord, I had example. Last page of my lord. Last page of. Last page of.
So you are liable to pay 88 rupees, 18 lakhs and 4 lakhs.
Loss.
So this is admitted.
Loss.
So therefore you pay after 6 months, within 6 months. I have heard Mr. A. Ahmed, the learned counsel appearing on behalf of the petitioner, Mr. K. Gogoi appears on behalf of the respondent. Railways. The petitioner herein is aggrieved by the non-payment of an amount of rupees 21 lakhs 4,76,000 and rupees 5,512, which the petitioner claims to be entitled to as per entitled to. It is seen that the respondents have duly filed their affidavits, wherein it is mentioned that the petitioner is only entitled to an amount of rupees 88.03 towards final bill amount, rupees 18,30,663 towards security deposit, and rupees 4,76,000 towards earnest money. This aspect of the matter can be seen from paragraph number 4, 6, 7. It is further seen at paragraph number 11 that the respondents have categorically mentioned that in the meantime, the billing, the payment process of the plan head of the railways have changed from P/1465 to B/241-32. And as such, some additional time is required to complete the necessary formalities for payment of the dues to the petitioner to the tune of rupees 88.03, rupees 18,30,663 and rupees 4,76,000. So taking into account that the said amounts have been duly admitted, the instant writ petition therefore stands disposed of with the following observations and directions. Number 1, the respondents herein are directed to make the payment of the amount of rupees, to disburse the amount of rupees 88.03 plus rupees 18,30,663 plus rupees 4,76,000 is equals to total amount to IVA within a period of 6 months from the date a certified copy is served upon the respondent number 2 to the respondent number 2 or respondent number 4, to the respondent number 1. See, okay, respondent number 4, 2 and 4. Now, if we give it for 2 persons, it becomes difficult because this is the respondent number 4. The same direction to make the payment is jointly and severally upon all the respondents of the present writ petition. What is this? Forest demand neither represented nor filed an affidavit. Oh, you were there. Yes. What is this?
Blacklisting.
One week till silent, I would have sent it for vetting.
I gave you 3 months. First, you don't appear. Isn't it a case of blacklisting? From 12/6/2024, is there a stay? Or stay is there? Okay, we have it up. Resultantly, the impugn order is stayed until further notice. Okay, we have it after 2 years. We issue rule. Yeah, we issue rule. You have not filed it. So there is no urgency. No. Heard Mr. I. Chaudhary, Learned Senior Counsel, assisted by so and so, appearing on behalf of the petitioner. Mr. I. Bhattakur appears on behalf of the Forest Department. The petitioner herein have assailed the order dated 21/2/2023, whereby the petitioner was put in the negative list of the Kaziranga National Park and Tiger Reserve, Environment and Forest Department, Government by the Environment and Forest Department, Government of Assam, for a period of 5 years. So pursuant to the filing of the instant writ petition, this court, by an order dated 12/6/2024, stayed the impugn order dated 21/2/2023 until further orders. 1 year, almost two, after more than 1 year, the matter was listed on 11/8/2025. However, the respondent authorities have not filed any affidavit. It appears, therefore, that the respondent authority does not have any urgency in the matter. Considering the above, list this matter how much time? 1 month, 2 months, 6 months, 8 months. List the matter. 11th of May 2026. In the meantime, an opportunity is granted to the petitioner respondents to bring on record their stand by filing their. Interim order is still disposal.
6 days. Publication the amount, so there is a publication providing the contract to go with the application. You claim some publication.
So,
Now they distribute them. They're saying you will create certain amount. Actually, we have paid for certain contextual amount, which amount is disputed, and they also raising certain amount against us. So the resolution is providing the contract, arbitration. So you have to go to that person.
the petitioner, I heard Mr. Lideka.
Yes.
Appearing on behalf of the petitioner. And Mr. N.C. Das, the Learned Senior Counsel, assisted by Mr. A. Das, appearing on behalf of the respondents. So the petitioner herein had approached this court seeking a direction upon the respondents to release a sum of rupees 48,72,774.53 along with interest at the rate of 15% per annum. So pursuant to the filing of the instant writ petition, the respondents numbers 1 to 4 have duly filed an affidavit in opposition, wherein a plea has been taken as regards the maintainability of the writ petition in view of there being the existence of an arbitration clause. Further to that, the respondent authorities have also denied the entitlement of the petitioner on various aspects which touches on questions of facts. From the materials on report, from the stand so taken by the respondent authorities, It is therefore clear, the petitioner thereupon has filed a reply to the said affidavit in opposition, reiterating its stand. His stand mentioned in the writ petition. This court have given an anxious consideration to the submissions made by the learned counsels appearing on behalf of the parties and have also perused the materials on record. The question as to whether the petitioner is entitled to the amount of rupees 4872,774.53 as claimed by the petitioner cannot be adjudicated in the instant proceeding, taking into account the stand which has been taken by the respondents, thereby raising various disputes on the entitlement of the petitioner. These disputed questions of facts, in the opinion of this court, can be resolved in the proceedings where evidence can be led. This court further takes note of that the agreement in question categorically mandates that for resolution of a dispute, the same can be done by way of an arbitration. More particularly, clause 18.0. Taking into account, therefore, this court is not inclined to entertain the instant writ petition, for which the writ petition stands dismissed. Be that as it may, the dismissal of the instant writ petition shall not prejudice or preclude the petitioner to avail remedies under the Arbitration and Conciliation Act, more particularly in view of clause 18.0 of the contract agreement. Further to that, the period from 10/5/2024 till date be excluded while computing the period of limitation.
Ready for response number 2021. Also, we need some example of that.
What?
Like that.
What is he claiming?
For non-payment of the
For which year?
payment on 18.
Why you are moving in the year 2024?
Yeah, correspondence was there.
Where?
The next see.
No, you are corresponding is different. Where is their correspondence admitting? Hmm? Where? Where is ONGC study? Huh? Where? Oh no. Yeah. Page 43. Please refer to the various correspondence during a meeting. The documents required for processing was noted and handed over to you. Out of those given documents, few documents were given. However, few are still to be submitted, which are brought out once again. Two salaries, so and so, so and so. Then, OKR construction. All requested have been submitted except for the proof of salary submitted, so and so. Delay in payment have caused significant need to pay material. I have proof of salary to the these calculations. Yes, what is this? Why you are not filing a reply? It's such a old matter. Before vacation. Okay. This is the matter on 19/12/2025. a final opportunity is given to the respondents to bring on record their stand by filing the affidavit.
I think I can clear.
I thought it was just now.
You have a copy? So you pay within 6 months?
Not from two doctors. We have stated here. We have to do it. So, in 6 months on our part, we have to also.
Central government is a party.
Hello, they have not completed their.
Is it your stand that the state amount is from the central government?
Yes.
No, but you have not mentioned that this is the amount which is pending from your side. Where is the counsel for a petitioner? Is pursuant to the directions passed by this court on 29/10/2025, the additional chief engineer, Water Resource Department has filed an affidavit in opposition, wherein it is duly admitted that an amount of rupees 1,78,848 is payable to the petitioner. Be that as it may, it is also mentioned that the said amount is in respect to a scheme said amount payable is in respect to a scheme pertaining to anti-erosion measures to protect Hualkusi town from erosion river Brahmaputra phase 5, wherein in respect to which 70% is payable by the central government and 30% by the state government. Full stop. Taking into account the said stand, this court fixes this matter again on 28/1/2026. In the meantime, the petitioner is given the liberty to implead the Ministry of Jal Shakti, Government of India, as a party respondent to the instant proceeding. Full stop.
Handling item 87.
Instruction. You did not submit the criminal antecedent certificate, which is mandated as per rule clause 18 of the NIT. So you are technically disqualified.
including me and other bidders, because 900 were there, they were bidding. They put it same price.
So council, you are not understanding. First, you have to be technically qualified. Isn't it the mandate of the notice inviting tender, more particularly clause number 3018, I suppose, somewhere it is there. Some clause is there. You have not put it everything here. Kindly come to 18. Where is it? Yeah. You have not given that a particular clause. Page 19, clause number 18. See. থানা আৰক্ষী থানাৰ পৰা তেখেতৰ পূৰ্ব জমা দিয়াটো বাধ্যমূলক. It is mandatory. You have not given that. It is there. What is the name of the petitioner? Rafiqul Islam. Rafiqul Islam. Where? Nice. A criminal incident. What is mentioned out here about the criminal incident? What is the remark given? Read it. Very difficult to. আবেদন করেছে, and then on the remark column.
My column is the career. সঠিক মূল্যত নিবিদাৰ দাখিল কৰিছে কিন্তু পৰ্যাপ্ত নথি সংলগ্ন কৰা নাই।
What instruction? It is on record. No case. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Ms. N. Bora appears on behalf of the PNRD department. The petitioner herein has approached the spot alleging that the respondent authorities have not complied with clause 13 core. Oh, no? 13 core of the notice inviting tender dated 26/5/2025, wherein it is stipulated that when the bidders quote the same rate, the lottery, the eligibility, the right to settlement would be decided on the basis of a lottery process. It is the case of the petitioner that the petitioner had quoted an amount of rupees 34,650. 34,650. Petitioner as well as the respondent number 6 have quoted 34,650. However, the respondent authority have granted the tender settlement in favor of the respondent number 6. Pursuant to the notice being issued by this court on 7/11/2025, Ms. N. Bora has produced a set of instructions dated 5/12/2025 issued by the Secretary. Secretary 51 GP Moinabari, isn't it? Gaon Panchayat, wherein it is being mentioned that the respondent number, the petitioner, though had quoted rupees 34,650, but did not submit the criminal antecedent certificate from the local police station as is required in clause number 18 of the notice inviting tender. Considering the above, this court have duly taken note of the said instructions as well as have also perused the comparative statement. The instructions as well as the comparative statements are kept on record and marked with the letter X, taking into account the above, as the petitioner have not submitted the mandatory certificate, criminal antecedent certificate, It is therefore the opinion of this court that the petitioner cannot claim any consideration in terms with clause 13 core of the notice inviting tender. Under such circumstances, this court does not find any merit in the instant writ petition. The writ petition accordingly stands dismissed. Fantastic. Give your name.
Handling item 61.
Yes, what is this? Why you are not doing it? Going for tender for Sialtek cattle market, Katigora? This court have duly taken note of the instructions which have been placed by the Chief Executive Officer, placed by the Block Development Officer, Katigor Development Block. So it is the opinion of this court that the said aspect be brought on record by filing an affidavit. First of list this matter on 30/1/2026. In the meantime, the affidavit be filed on behalf of the respondent, PNRD Department, without fail on or before 27/1/2026.
Item 62 and 63. Mr. CM.
Milord, kindly take up item number 63, Milord, that's the written repetition where everything has been incorporated.
I'm appealing now, but there's something to take over. Your, this matter, in terms of the last particular, the records of the technical evaluation. Well, when we have received the records today itself, it's bulky. Lord, we have to go through the records, Lord. Today only we have received the records.
Let's have it tomorrow then.
I am appealing for LMQ matter.
Oh, very well.
By direction of this court, we have already filed the evidence for this.
Let's have it tomorrow at 2. Because otherwise there is no time before vacation. Because 11th I'm having a division bench.
Correct. No, all that I was trying to submit is lot, records can be produced. What is the?
No, but today we have this, we have not done.
No, I was also told by Mr. K. Gogoi, he is in court number 1. There's a debt reference going on, so court number 1, he will be over by 1 hour time. Now, if you want to do it in a piecemeal, it is different.
Tomorrow, okay.
Taking into account its urgency of the matter, we'll take it up at 2. And they have filed an affidavit today. You have a look at it also. Okay.
The affidavit was served upon.
Okay. Prior to that. Na? You have filed affidavit.
We have filed it.
Mr. Chaudhary, I'll let you only aspect where I am concerned is meaning as regards the second clause I told you on the earlier.
4.2.4.32.
Whatever may be, on the aspect regarding the undertaking. I've seen your undertaking because I have heard your matter on many occasions out here. Only you need to satisfy me, find a judgment out here that you can challenge the tender condition after participating. That's the way. Because you participated one day, although you signed the
On 26.
on 26, but it got filed
Filed on
on
28.
28 on
And 27
27th you
was the last
submit. You submit. So therefore, the filing date would be the
Because I have found out a judgment where the honorable court has taken the view that it must be filed reasonably. within a short period of time,
No.
before opening.
No, opening, I'm not on the before opening, but once you have submitted,
Yes.
can you challenge? That is the only issue.
Well,
Once you
that is
satisfy
it,
me,
yes.
your hurdle, therefore your first item, therefore that item is the most important.
Correct.
You satisfy me, remaining I don't have any problem.
But that's
Only
the-
that is the challenge.
That's the first item, which my learned petition was filed. If I got made a party, so after the third petition, we were made a party. What I have looked into it and found that there are certain environments which in the third petition, they rely on the first petition. So which we are not privy to the statement which has been made in the first petition. That's I'm just pointing out before the court. This is what they have.
We can supply a copy.
No, that's fine. That's what I just saying that once it starts, then your lordship may say why you have not pointed out. This is what. They have made certain allegations which, but we are not a privy to the first instance, they will not be a party in the first. This is just pointing out to the court.
Mr. Chaudhary, can we have it then on 17th? Why I'm saying so? Giving him a copy, asking him to reply there. Then this problem is solved by passing an order.
Absolutely.
Well, could you done 16?
16 you may, but I am not sitting out here, so that is why. 15, 16 I am not sitting. So therefore, I don't know, I can't give a guarantee about other courts taking up the matter on an urgent basis. Why this problem which is there? Otherwise, they will keep on harping on that problem. So, because you are referring to that.
My God, on 17th, can I wait for some upgrading or something?
Yes,
17th, which is
No,
the
I'll
second
fix
time
it
I'm
up
not
too.
there.
Oh, you are not there.
I can finish, but if I get 1 hour time, it is enough for me.
My lord,
If you lordship permits me. at
Then
12
I'll
o'clock,
pass an
1
order.
o'clock,
I will record his submission, what he has made.
Yes.
Thereby giving you the liberty to give a copy and asking him to submit a reply. Then he cannot later on take that plea.
Yes, yes.
Although he is not a
17th,
party.
only thing is that Lordship will give me permission to upgrade it. By 1 o'clock, I can upload. 1 hour is good enough time for. I made a yes also.
After the motions, I'll take it up.
yes.
I'll take it up. Huh? I
Okay,
think
right, right.
by that manner, we can very well take care of his objection.
Yes.
Because I thought of pointing out for the court before it starts.
Now, end of the day, these are the adversarial litigation, why not by landed fund should not take this. But after
No.
all,
In fact, well, I was taking the earlier petition also, I took up that. Then you say that, okay, the second petition, you have one file, then you withdrew it and file the second one. Okay. A 6625 would like Mr. Didas, the learned senior counsel assisted by so-and-so, appears on behalf of the private respondent number,
We are for 3 months.
private respondent number 3. He submits that in the writ petition, various averments have been made, thereby making a reference to WPC number 5051/2025, wherein the respondent number 3 is not a party. He further submits that in WPC number 5051/2025, there are various allegations made against the respondent number 3.
No, actually, we are not aware, because what allegation exactly is a rule? But we say that they are relying on the first, that's all.
He further submits that in WPC number 5051/2025, there are various averments being made upon which the present writ petition is based upon. And as the respondent number 3 is unaware of the contents, it would prejudice the respondent number 3 in the present proceedings. Mr. Ken Chaudhary, the learned senior counsel appearing on behalf of the petitioner, however, submits that taking into account that there is no interim order passed, the matter requires an urgent disposal. It is the opinion of this court that this court has duly perused the writ petition, the contents of the writ petition in WPC number 5051/2025. And it is the opinion of this court, and it is seen that in the said writ petition, the petitioner have only assailed a tender condition, as well as have sought certain directions so that the petitioner can participate in the said tender. Be that as it may, it is also the opinion of this court that if a copy of the writ petition is given and liberty is given to the respondent number 3 in the present writ petition to submit a reply thereagainst if so advised, the prejudice, the question of prejudice would not be there. Because accordingly, list this matter on 17/12/2025. In the meantime, during the course of the hearing, Mr. So-and-so assisting Mr. Ken Chaudhary, the learned senior counsel, have already furnished a copy of the writ petition in WPC number 5051/2025 to so-and-so representing the respondent number 3. Liberty given to the respondent number 3 to file an additional affidavit in the present proceedings as regards any averments, it's so advised, as regards any averments made in WPC number 5051/2025. The said affidavit be filed on or before 16th of December 2025. Liberty given to both the parties to mention the matter for upgrading on the next.
There is an interim observation that will continue. That there will.
That is there already. There, don't worry. I've already said that there is nothing on this. And further to that, Mr. K. Gogoi, appearing on behalf of the railways, shall produce the records on the next day.
Item 18.
Oh, yes, none appears for the petitioner. Now you are appearing. Yes, tell me. What is this? What are you challenging? Read the 1510 order. It's an appellate order, authority's order. Mr. Das? Mr. Das? What is your case?
fourth story, six from one. And having some extra spaces in the premises, they have decided to rent out some of that space to other parties. And therefore, they applied for commercial power connection. And for application, they have filed on 9 of very stages. And thereafter, so many kind of several reminder application also submitted. Only on 15 to 2016 data entered on 5/6/2016, they had come for inspection by the and thereafter served an arbitrary notice of 2016 alleging that the petitioner is indulging in malpractice by linking electricity for other purpose, that is industrial connection used for commercial purpose. And thereafter, they have served a provisional bill on 15/6/2016, that is 20 to 26 lakh 7,444. And thereafter, on 16/6/2016, they have passed the EQ order, and thereby they're holding the bill as a provisional bill as the final statement. Being every manner petitioner approached the honorable court as at that time there was no appeal authority. And the honorable court on 24/6/2004 has passed an interim order and directing the petitioner to pay 8 tax to the respondent. And thereafter on 24/6/2014, the honorable court disposed of the petition directing to approve the appeal authority. And appeal authority on 15/10/2016 passed the order and thereby reducing the penalty period to 12 months instead of 12 months as imposed by the respondent authority.
Yes, after that, did you carry out the new assessment?
Yes.
My lord, they have passed the bill, my lord, assessment bill, by suppressing and my lord, suppressing the notification, government notification letter 5/11/2014, my lord, wherein government circular was passed, my lord, where about quota and post storage service has been placed under the industrial category of service under understanding act. It is a kind of page 44, my lord. This notification.
What does it say? MSME Act, what does this notification say?
It says that warehouse signs are under industrial category.
So,
So they have assessed the bill, my lord, that we are seeing malpractice by using commercial connection.
how does this have any relevance?
My lord, they have.
No, pursuant to the appellate court's order, appellate tribunal's order, there was a direction that don't do it for the last 12 months. Do it only for a particularly limited period. Have you done that?
System will has been drawn up.
I'm asking you, have you done
System
that?
will has been drawn up. Since they had already deposited some amounts, that is
Then that has been,
adjusted.
so they are entitled to some amount.
No, because they already initially filed an appeal. 3% of the amount has to be deposited.
No, they were asked to deposit 30%. So accordingly, they deposited 80.
Yes,
So now therefore the question is, have you carried out the fresh assessment bill?
which I just get the instruction. Fresh assessment, because perhaps what I was instructed is, since the amount was reduced, your lordship, fresh assessment is not necessary, because they have already deposited 30% of the original amount. And this new amount that will be, the figure that we arrived at only 4 months ago. Perhaps that should be less, it should be being adjusted in order against the current rate.
So therefore, there has to be a bill.
There has to be some report.
So where's that?
That bill is not on.
Get the instruction. Okay. This court inquired with Mr. K.P. Pathak, the learned standing counsel of the APDCL, as to whether in pursuance to the order passed by the appellate authority dated impugned in the instant proceeding, any bill has been drawn up. First of, Mr. K.P. Pathak, the Learned Standing Council, submits that he will obtain instructions in that regard. To list this matter again on 31/2026. In the meantime, the instructions be placed before the court.
Can maintain.
ESPI. Oh yes, what is this? Oh, this one, original jurisdiction.
File the title. But after the contract can file. In view of the contract, in the contract, they have challenged the registration itself. So when the registration was challenged, as per the provisions of the Patent Act, it has to be decided by the High Court.
As a written statement being filed, issues framed.
Written statements to the plaintiff has been filed with us. Before proceeding with the main case, there are two IAs in it, and because those can be closed in days.
Which one?
Two these cases are there. One is for injunction. Filed by me, that is IA 3021. 3021.
Which one? Adani Transmission Limited.
3021.
I think that's 302.
What are these miss cases? There are two miss cases.
There are two.
3021. What is that miss case?
Once order 39 was filed by me only.
Regarding
Regarding for temporary injunction, the suit was filed with a prayer of permanent injunction as well.
And-
However, Lordship, now the patent has already expired. The patent that I was holding has already expired. Under such circumstances, I cannot probably pray for a temporary injunction restraining the other parties from installing the patent because it is in public domain now. So my prayer,
and how does the suit remain? So suit is whose?
the suit is back.
Injunction paid by whom?
Injunction treatment. Apart from that, there are monetary claims as well. That will remain.
Huh?
That apart from the injunction, there are money claims as well.
Money claim.
As my pet, I am the holder of the patent. I have claimed infringement of my patent by the defendants. I have paid for permanent injunction restraining them from using the meter, which is under my patent, and also for those meters which they have installed, I have claimed for damages and other monetary reliefs. So the injunction part, because my patent in the meantime, after filing the suit, has already expired. Once the patent is expired, there is no provision to renew the patent. So it goes to the public domain. Anyone can use the patent product. So now, with the injunction, I cannot probably pay for the injunction because it is in public domain now. We have to use it.
Same permanent injunction also you can't.
Permanent injunction will also. Now only the monetary portion will.
So only monetary. Now what is he asking? Because you see, it's now because of the counterclaim. The suit has come before me. Now what is his counterclaim?
His counterclaim is my patent registration. Patent itself was not patentable. The subject matter was not patentable. He prays for cancellation of the patent. Patent is granted by the authorities that can be cancelled only by the High Court.
Now are you taking steps for the purpose of renewal of the kingdom?
Patent that cannot be renewed.
So therefore his counterclaim has also become infructuous.
So that won't be the case. So actually what happens is that once the patent expires, the revocation still stands, especially because revocation is in the judgment of the Delhi High Court which deals with the exact issue. What happens once the patent expires, which held that even after expiry revocation can be sought, because then also consequences of the revocation still have to follow. And the name will then get struck off of the
So what
register.
is your counterclaim?
There are two counterclaims. There are two separate respondents. One is by the defendant number 2 and one by defendant number 3.
So you have, what is that?
I'm seeking a
What is your
revocation.
patent for? This is the counterclaim.
That's the one I'm trying to here. On behalf of defendant number 2, there's a separate counterclaim on behalf of defendant number 3. 583.
Hmm?
I think there's a 583.
That was any file. Wow. The claim, specification number 2 of the hearing. The impugned patent ought not to have been granted and a decree be passed. Consequently, the title suit number can also be dismissed. You are not asking for revocation.
I am not. So this is the consequence will be revocation.
You say that your declaration that the impugned patent ought not to have been granted.
Yes, sir.
That's not revocation.
Because the expiry is, when I filed this, the expiry has already taken place.
So therefore, but this is not a prayer for declaring for a revocation.
Your Honor, I have 4 or 5 paragraphs that I made these.
No, Mr. Counsel. Don't come up with all these things, 4 or 5 paragraphs. Why should I look into all these things? That is not your relief out here.
The relief is that the.
No, you are asking for a declaration that the impugned patent ought not to have been granted.
That is the revocation itself. That is lead to a.
You are not asking for a revocation of the patent. There's a difference.
The revocation will be done by the registrar.
Mr. Counsel, revocation would not have been granted, but where is the consequential relief for that?
The consequence over here, Your Honor, will be that the.
Mr. Das, you have to understand. When you are seeking a declaration, there has to be a consequential relief in this regard. Where is your consequential relief?
That suit
On
number.
the basis of that, we dismiss your petition. No, your file order 711. Go as per the provision to section 34. We dismiss this petition. Reject this counterclaim. Once I reject these counterclaims, then again it goes to the trial court. Fantastic. Okay. Oh, you don't need to file. The court can on its own can do it. It is rejected without asking for consequential relief.
Your Honor, but then give permission to amend the prayer.
You should. You don't come up with this.
This is the language we.
This is not the language used. Okay, we'll have some other day after. In this type of files, first thing, civil suit. Is this matter after vacations on a particular date? We have it on 29th January. File whatever you feel like filing. Yes, Mr. Dekar, what are you doing here in this matter? Who are you?
We had also filed an application
For
for return of the claim.
return of the plane.
Because initially it was filed before the district judge. Now, we urged the point that since it's a commercial dispute.
No, now the matter has come up, so those applications has become redundant. So that has come. But have you seen the prayer, what he has made in his counterclaim?
Yes.
Can that prayer be granted? Merely seeking a declaration without consequential relief. Possible.
If the register, they must perhaps seek for cancellation of the registration.
Nothing there. Then if the cancellation from the registry is required, then he is asking that this should not have been granted. Then he has to ask for revocation. Where the two players? Nothing. That case we dismiss on the next day. Not this year, next year. Next.
10:20.
What is this matter?
Business settlement at the Muki fishing market. And it was settled in favor of me. And thereafter, on the complaint made by the private respondent, the government had stayed my settlement. So lordship had stayed that order. Therefore, I'm running the market, right? So the main issue here of why lordship entered the interim was that if there is a dispute in the settlement given by a government side, then the dispute resolution authority as per amended act with the number. And in this case, the private respondent directly approached the government.
What is your instruction? Affidavit? Hello, this, madam, it's a whole matter. No matter, 1/8/2025, notice has been issued, stay granted. What is your period for collecting the license? How long?
4 months.
Huh? How much you were appointed as what? Tax collector?
Settlement.
Huh?
Settlement, order is need to be.
Page? Where?
Page 22.
Page?
22.
Period 25-26, starting from and settled for the financial year has been given to Dhruva Luthini as such. Lease is hereby directed to be now it has been, you have already paid that amount.
Yes.
Now they are not allowing you to collect. Where is the impugn order?
I collected for 2 markets and thereafter they did not allow me on the basis of the additional secretary's order. And thereafter I approached this court and lordship has stated that on the ground that if there is a dispute, because there is an amendment in the act now, that says if there is a dispute in settlement, if it's a cow panchayat matter, then it should be referred to tribunal operation. What the private respondent did is that they directly approached the additional secretary. An additional secretary passed.
Ah, yes, yes.
That was the meaning. So as per the amended section 105.
Good, good. So what is your stand? We will let him collect for, we have it in the month of July. Okay. It is seen that in spite of notice being issued and an interim direction being passed as far back as on 1/8/2025, the respondent authorities, more particularly the PNRD department, have chosen not to provide the instructions or even not to file the affidavit or even provide instructions. It therefore appears that the PNRD department is not in any sort of urgency in spite of there being an interim order. Accordingly, list the matter on 17th of March, 23rd of March 2026. So some interim order passed earlier shall continue till the next date. The counsel appearing on the PNRD department shall be at liberty to bring on record a stand by filing the affidavit on or before the next date.
21.
Why, Mr. Non-payment?
Amount is paid by the server system. What the other instruction has been.
Why the petitioner has not been paid? You wanted the instruction, take the instruction. Last time I wanted to dispose it off. You said, give me one single chance. And I gave you almost 1 month.
Yes, I have the instruction.
Fantastic.
Here, Mala Superintendent, the amount of this 190,200 is the evidence.
He's asking how much?
1,93,200.
Then pay.
Paid by the service sector. In 2023, in the financial year 2023, EPA was issued by the court is amount, not a petition. But when it deposited the city quota, like I used to like a check for something. For the bank, it's a 4 rupee of insufficient fund. Thereafter, no proposal as service come up from the city of court.
So we pay within 3 months.
Clean paper.
The deposit. Pay within 3 months. Get instruction.
And it will be the only one. I got a, just now I got the oral instruction from the authority, not smell it. Why statement may be reported?
No. Ask them to put it on here by something, words, black and white. Because you never know. You see, you have put it today. Why do you take a risk? We have it tomorrow. To get the instruction. Mr. B. Gogoi, the learned standing counsel of the Samagra Shiksha also submits that there is no dispute as regards the entitlement of the petitioner to the amount of rupees 1,93,200. He further submits that due sanction was also granted. However, at the time when the said, what is that? The PPA was submitted, there was insufficient fund for which the petitioner could not be paid the dues. Be that as it may, the said amount would be paid to the petitioner. It is the opinion of the court that the said aspect be brought on record by way of some instruction so that appropriate directions can be passed. List this matter on 10/12/2025, on which date Mr. B. Gugoi, the learned so-and-so, shall produce the instructions.
22.
Entitled, not entitled? Very good. You can do-
They have cleared in respect of the verification has done, and 11 verification is pending.
The amount into 20,696 is admitted, and the amount is 21,79,890 is understood to be.
20 lakhs we have got. Okay. A paragraph 6 to police case. Paragraph 6 to court ko dibo. Insofar as answer direction tolot into dibo. 20 lakhs 88,896 first direction be paid within a period of 3 months from the 6 months from the date a certified copy is served upon the respondent number 3. Who is the DGP is 3? As regards the amount of rupees 21,79,890, the respondent's authority shall carry out the necessary verification. And if it is found that the petitioner is entitled to the said amount be paid within a period of 6 months. Said amount or any amount arrived at after verification within a period of 6 months from the date of the so and so. Paragraph 6 to put kuri, baki thini amar normal directions.
33.
Affidavit file করেছেন। Yes, no instructions.
Sometimes you can do
Okay. It is, huh? What?
extra copy of staff only on my keyboard.
3?
Keep well man. Sometimes it's
Okay. Mr. M. Sethi, appearing on behalf of the government, submits that he could not obtain the instructions in view of the fact that the extra copy was served only on 3/12/2025. List this matter again on 6/4/2026. In the meantime, the respondent shall file the affidavit as to whether the petitioner is entitled to the amount as claimed, and if so, when the said amount will be paid.
24.
Non-payment? What is your stand? Huh? How much? Where is the instruction? Where is the instruction? Give it to me. Irrigation department. Miss D.S. Neog, appearing on behalf of the irrigation department, submits that she has received instructions to the effect that the out of the claim amount of rupees 353,775, an amount of rupees 293,372 is admitted, whereas an amount of rupees 61,403 may not be paid. May directions be not issued to pay, taking into account that there is some technical objections. It is the opinion of this court that this aspect be brought on record by way of an affidavit by an officer not below the rank of an additional chief engineer. And further detailing as to what technical objections for which the said amount of rupees 61,403 need not be paid. Lists this matter again on 28/1/2026. In the meantime, the said affidavit be filed on or before 22nd of January 2026. Madam, file affidavit, otherwise personal appearance.
25.
How much? Same amount that an amount of rupees is pending, 93. Then agriculture. This is agriculture.
The similar matter has already been disposed of by Mr. Robert, that they are paid.
93. Director of Agriculture. Yes, what is my order?
826 plus 57, below order. So I got,
Are you paying for a petitioner?
I'm state for, state for.
Huh? Because that submission should have come from his side. So maybe Mr. So-and-so did not get the time to come to this place. So maybe he has taken the recourse.
I just want to pay a price.
Absolutely, this type of order I don't pass. My orders are different. So this is the amount which the agriculture department will do it. To verification to for us to make payment within 6 months. You appear for Seeds Corporation.
Yes.
So are you to G Bora for agriculture? Finance.
26.
Admitted, huh? Verification. Ravi Brothers, what is this?
So it's taken, the redevelopment one from trying to. It's a fellow speed factor.
The entire claiming 178.
The mechanical division is done itself. But they want some time to. Got it planned out.
Mr. N. Upadhyay, Standing Council of the Irrigation Department has placed before this court an instruction dated 6/12/2025, whereby 4 weeks' time have been sought for, taking into account that the mechanical wing wherein the petitioner had carried out the work in question is no longer in existence, and as such, some more time is required to trace out the relevant documents. Taking into account the above, the said instruction is kept on record and marked with the letter X. Taking into account the above, lists this matter on 18/2/2026. In the meantime, the affidavit be filed on or before 11/2/2026.
57.
Similar.
It will exclude another one document. We understand the irrigation departments really do not have the money or resources to get another photocopy.
No,
Then give it.
here, even in the same, it's not.
So what? But both are different files. Then will you allow two petitioners to come here?
All the.
28.
The petitioners are entitled to 1% in
Who is paying for a school for those persons?
I'm paying for respondent number 3.
Yeah.
You got the 50% or something amount I directed
The
them.
principal amount will be one.
Huh?
The principal amount will be one.
It's only the question of the interest. Huh?
There are also one restriction of which we are paying.
Is 10% the statutory limited? Statutory interest? Is there any way of reducing it?
From the kind of fee of the payment of principal amount, then the affidavit of exemption. Simple interest.
In both the cases, you got the payment.
Principal.
So what is your ground not to pay the interest?
The ground is actually no longer my lord interest or my lord has been calculated by them. The ground is there when the petition has been filed, my lord. it was-
That has already been, unless you file an appeal against this order of 1990.
People office keep, my lord.
I only kept the interest aspect open.
Rule 7 and sub rule 10, madam.
Ah.
It is a period of 90 days within which, my lord, they also have filed this petition.
But that I have already rejected your prayer for
No,
that.
no, that has not been rejected. madam.
Can you see? It is relevant to take note of that the petition respondent number 2 have given due reasons by which the respondent number 3 herein was permitted to file the application beyond the period time. This court further takes note of the petitioner did not object to the condoning of the delay before the remand. And as such, this court is of the opinion that the petitioner do not have any case challenging the proceeding before on this aspect.
That petition was not even filed. That is my case before your lord. Without that petition. being
That
filed-
aspect has gone for a 6. You have to challenge this order. Without challenging my order on that day, I gave you okay a relief for the time being, 3 months. To gather the resources to pay the interest. Isn't it, madam?
Not right.
You remember? Mr. Chaudhary, I remember that day. You see, that day I only gave you time, okay, you pay because of the fact that on that day, you have duly agreed also to pay the gratuity.
Yes, yes.
So
Because the case
now,
is like this,
now,
madam.
therefore, I have made an observation in paragraph number 11 of my order to that effect also. But the question of interest, I said, okay, let us give him 3 months more time. In the meantime, they can gather more money. How much is the interest?
As on, in terms of the order.
How much is the interest?
Interest comes around, in this item number.
Around 2 lakhs more, madam.
Interest comes around 2,65,500.
How many months you are going to pay installment?
Interest has to be statutorily be paid.
I'm not asking not to pay. I'm installment. That is, otherwise nothing else.
Let me take my instructions from it. Come up on that.
Huh?
Let it come up next week, my lord. I'll take my instructions.
You obtain that instructions to the effect, how many months? I'll give you 2 installments, but finish it before the Assamese New Year is over.
The main, my lord, move, my lord.
No, remaining is not, Mr. You see, the fact remains that the question does not arise as regards payment of the entire. Other payment you have already made out there, that is the right, and I have upheld it to that effect that finding that this is the amount to be paid. Now, if it is the amount of rupees 2,83,000, you take before vacation, before the end of Assamese New Year, which we go by, the entire payment has to be made. So take your instructions. Payment has to be made. These, Mr. Chaudhary, all these things are okay, but the fact remains out here, is the beneficial legislation.
Yes, madam.
Beneficial legislations, I am not going to put my hands out there unless it is gross perverse.
My lord.
No,
on that very day, my lord, I had
Mr.
suggested that
Chaudhary-
I had come across your judgment, my lord. On the judgment, my lord, that Compass Promotes case, where you made a, my lord, referral. That, my lord, these are, my lord, continuing offences. I had submitted on that, my lord. But then, my lord, what I wanted to, my lord, lay before your lordship was the fact that
the statute itself provides a limit within which, my lord, these claims are to be made, my lord. And if these claims are made, my lord, 4 years after that, my lord, date, my lord. Because initially they had accepted whatever money was paid to them.
No, only
Then you-
reason
My lord.
only reason I can reduce the interest is only on one aspect. Is that the interest will be calculated from the date of the application.
From the date of the order.
No, date of the application, not the date of the order. If you agree to that, it's okay.
Let me seek my instructions.
On that is, because you see, you have approached them very late.
My lord, there is humble submission, my lord, under section 7(2), it was a mandate upon them to file an application as whenever the gratuity became due. It was upon the obligation upon them to file a application before to inform me and before the controlling authority to that the gratuity has been due, that the person has retired. That not having been done, it's not up to me. My filing an application, approaching them is optional, my lord. That is clearly mandated in section 7, subsection 2. So they having failed at doing that, and they were giving gratuity for 1 lakh, which is otherwise their internal regulations, under their internal regulations. They have made the
But you took the gratuity, na?
I have taken a gratuity.
Then why didn't you raise the plea immediately then?
We didn't know, my lord, that time because everybody was taking the gratuity.
No,
But
you
they had
took, no, you come up later on when you learn that somebody, there is a change of a particular notification has come in or circular has been issued. Then look here, now for other people are getting more and then you realize, oh, we can give more money.
My lord, but because I was concealed from all this.
Isn't that not the case?
But
I
was
remember
concealed from-
that.
That is why lordship that used the word fence sitter.
Huh?
They
The
brought-
word fence sitter was, that's why it fell from lordship.
Ah,
These
yeah,
were
yeah,
fence
oh.
sitters.
So therefore the question is, how much would be the interest from the date of the application? Find it out, both of you. And you, in other case also, if I go against him, in his favor, you have to pay on or before the end of the Assamese New Year. And otherwise, then we'll process the order. Otherwise, Ms. Yudas, the Lalit's senior government advocate, additional senior government advocate submits that an affidavit has been filed in WPC number 5542/2025. And the instant matter and the said affidavit will duly cover the issues involved in the present proceedings. Mr. So-and-so appears on behalf of the respondent number 3. List this matter along with WPC number 5542/2025 on 18th of December 2025, on which day the counsel appearing on behalf of the petitioner shall obtain the necessary instructions. You also.
My lord, submission, my lord, my submission would be from the date of retirement, for the interest.
That I know, but what way you doing all this while?
My lord, if I may, if lordship may allow me to submit.
You find out the calculation to the
Whatever submit, this is sufficient, affidavit on whatever is said. Let me be a counter and.
No, that has been gone.
Very well. I can do one thing. Ask him to file an affidavit properly. I vacate the stay. Let it, you make the payment in the meantime. We'll consider that after 4 years. Because you see, no, Mr. Chaudhary, you have to understand, the principal having been paid, there is no accruing of further interest. Because of my order, the interest has stopped. So therefore, I can't delay it. It is my burden. Otherwise, I have to then make an observation that that amount which is being paid shall be apportioned later on. Should I pass that order?
So I don't say that, my lord.
So
Because-
otherwise, no, because it is my duty as a court, having directed you to pay the principal, the interest has stopped. So therefore, I have to finish it off early. If I can't finish it off early, then I have to change the apportionment on 18. Get your instructions.
Step 29.
Yes, what is your instruction?
That NOC has been directly comes from the office of the concerned town president. So they, also the district commissioner has got NOC, they both from the office of the BPO, but directly it has come from the office of the secretary. In that time, yes.
No, in paragraph number 4 of your affidavit, you say the senior superintendent of police to verify and report whether the hotel may be ordered to reopen or not. That is the instruction I sought for.
Yes. Last of all, paragraph also, I have given one extra. There was one communication of the senior superintendent of police to the district magistrate. They said that there was that on a particular shop, there was not street or law by the police authority. That people was well. One communication has been sent from the office of the senior superintendent of police, the district magistrate. Prior to the lordship's order, they said that they have not blocked that premises. So from their side, I think not to know. Now, the petitioner wants to include the burden of that. He has opened the shop.
Open.
Yes.
Very good. Yeah.
Yes. Started.
But you cannot sell beef there. You've given an undertaking. Where? Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the petitioner have, the district administration have permitted the petitioner to reopen the shop, isn't it?
He has informed that he has opened the shop. What basis he has opened the shop?
Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. S.R. Borwa appears on behalf of the district administration. Mr. So-and-so submits that the petitioner have informed him that the petitioner has opened the shop and as such would not like to further press the instant writ petition. So considering the above, the instant writ petition stands closed on withdrawal.
Item 30.
After checking the case, my lord, after getting affidavit, my lord, I take it virtual with the page mark, my lord. The government does not fulfill, my lord, and I think what the resume has submitted the affidavit. So can you pick up my case, my lord? That will suffice, my lord. NID says that your lordship will see at page 27 onwards. General condition says, my lord. General condition that page 48 is the ineligibility criteria. Where, my lord, they do not have that much.
Who is paying for the respondent?
Where do my lord find the affidavit?
No, the private respondent. Yes, what is your stand? What is your stand?
It's affected the synopsis of the petitioner is that, my lordship.
Have you filed your affidavit or not?
Not it.
Right? When did you receive the notice?
You have some possible also. The affidavit reply has been authorized ready on, but a few cases that was got from Bangalore itself, it has been authorized and prepared at Bangalore.
So certain cases, Your Honor, it's not properly legible, so for that purpose, legal operations, so we have to clear it and have the affidavit.
Otherwise, today it takes 4 months of consideration of the order, my lord. I have filed affidavit lawsuit pending available 17/11. 2025, page 241. I have some false and dusty service.
Now, what is the work order given now?
No, not yet,
My lordship,
not yet.
now they have submitted a representation, which is worked as annexure. Seven method.
You have filed an affidavit, na?
Yes.
What is your stand?
That guided in page number 48 of the petition,
48.
48 of the.
This is the condition which I have taken.
Yes.
1.1 minor. Technical criteria. A proof of technical details confidence the tender must satisfy the following criteria. Would have operated a mechanical laundry of minimum capacity of 4 tons of linen per sheet while washing the minimum 4 tons of linen per sheet for continuous period of 12 months with a qualified period. That is financial and 3 previous financial years. Accordingly, the page number 443, they have 443 on my reading. and 442. There are two pages, that is experience certificate. Experience certificate, satisfaction certificate.
Of this MA Leotech
Leo,
process.
they have-
Oh,
So here, my lord, name of the word supply of Indian and mechanized laundry service. And this is the ERY.
Why?
My lord, can we,
Mr.
My lord.
She's submitting.
Yes, Lord.
Don't interfere. Yes.
supply of Indian and mechanized laundry, and then we come to the page number 444, my lord.
Yes.
Detailed linen was 4 day per day, my lord. This is the requirement as per clause 1.1, my lord. And this, though this certificate is for supply of linen and mechanized laundry service, but the four details linen was, that is laundry service, but the mechanized laundry service. So this is the requirement, my lord, they have fulfilled, my lord. Then kindly come to page 48 to Roman 7. Roman 7. Railways have reserved the right to seek independent confirmation of representative submitted by the tender from the respective issue agencies above the secretary documents of the award. Tenders are submitted with other verifiable document establish that they fit above technical criteria. Accordingly, they send a letter to the Department of Medical Education, Andhra Pradesh, that is in page number number 452. Page number 452. On first, Director of Medical Education who issued that certificate. And their reply.
Page 463.
Yes, 463. Reply from Director of Medical Education, Andhra Pradesh, madam. 464 is the relevant matter. Laundry capacity both parts in of 8 hours.
You file your reply. It is seen that the respondents have, the respondent number 3 has filed a detailed affidavit in opposition. Gustav. Mr. So-and-so appears on behalf of the respondent number,
What's the right? What's the right?
respondent number 4, and submits that although the affidavit in opposition was prepared, but the same could not be filed on account of certain defects. He submits that within 1 week, the said affidavit would be filed. 1 week.
Your lordship may give us 10 days because it has come again from Bangalore. That's how.
Why, what is that?
Okay.
This matter on 21st of January 2026. In the meantime, the affidavit be filed on or before 7th of January 2026. Petitioner given the liberty to file reply on or before 19th of January 2026.
One time, my lord. Till my lord. Next week, my lord, go what are to. That was.
Not satisfied. These materials are, you file a reply against them.
Otherwise, my lord, today is the police court comes, condition of the interim order.
Huh?
Otherwise, today is the consideration of.
This court have duly considered as to whether any interim order is required to be passed or not. Gustav, taking into account the affidavit filed by the respondent number 3, this court, for the present, is not inclined to pass any interim order. The same shall be considered on the next date. If the writ petition cannot be disposed of on the next date.
46 and 47.
What is this matter about?
I am appearing at item number 46. I believe it is connected with 47. Not certainly. Reason for the connection.
47, I see, it's a different issue, I think, only 10. In 47, or should I exactly measure and kindly give us some time in the 47.
I'm for.
What do you want?
In
I have not given me. I already they have basically filing for item number 40. 49, 47. 46.
All of you require time?
No, you're in 46, the reading the company. That is as far as 46 is concerned. I'm not in 47. Sorry.
In 47, I need some time to file it, and my submission is that 47 is a different matter, 46 is a different one. I think it is wrongly said.
46 and 47 are not.
What is your case?
Yes, so my case is under the National Food Security Act. I'm representing the Association of Fair Price Shop Dealers. Now what happens is, in the year 2013, the new act comes, and which is implemented from 2015 December, almost about a decade ago, almost to the month. And when the transition is taking place, the regime of how the fair price shop dealers are paid is changed. If your honor may have the one rule is relevant here. If your honor may have page number 391 of the respondents affidavit and opposition. It's got the relevant rules. But under those rules, I am to receive a certain margin, specifically 143 rupees. So that margin has not been paid. 30% of the margin is erroneously given to the authorized agency, also known as the TPSS.
You are the fair price
Yes,
shop dealers.
yes.
So here what happens, the total amount is to be paid by the central government?
Yes. And so, yes, no, not 70% and 75 and 25. So there's a split. What happens is in the Essential Commodities Act and the earlier regime, it was a commissions. There was a 70-30 commission split that is to take place. And the monies were collected from the ration card holders themselves. But under the NFSA, the regime changes. And now they do away with collecting any money from the ration card holder. The central government and the state government together pay the GPS, pay the authorized agencies as well as the fair price outlets. Authorized agencies are the ones who have to pick up the food grains from the FCI godowns and then they have to deliver it to the doorsteps of the fair price shopkeepers. And so they get a certain margin for that. And it's, I think, quick to get a margin. And similarly, the fair price shop dealers also get a margin for distributing.
What?
Also get a margin for distributing. So once the grains are handed over to them, then they have a thing to distribute to all the all the beneficiaries who will be assigned to their shop.
So
that's
per kilogram, you get 43 rupees.
And
or per quintal?
Per quintal, it is, there's a basic margin and an additional margin. So per quintal, it is 148, 143, I think it's 180 now. And the additional margin is for the EPOS machine, electronic point of sale machine. So that's a 17 rupees margin for that. These are the two margins that I am using. Now, how it works is that under the EDPS, that's the targeted food public distribution system, there's a rule 9 that sets up the fair price shop dealer. And under that rule, they have to make a notification saying that, okay, now the fair price shop dealers are going to be paid this amount of margin. And the state government has some leeway. Now, 143 rupees that found here is the maximum amount that the central government will pay 75% from. 75% because we are a special state. Otherwise, it's 50-50. So they said more than 75%, more than 143 rupees, you will not pay anything above and more than 75% of that. But the state government now has the ability, the power to increase margins given various factors like topography, distance, etc., where the central government would not share that burden. Or they can even reduce the margin. They can say not 143, 100. They can say that, depending on again which variety of factors. In which case, the central government will only share 75% of the reduced number. Now, from 2015 onwards, the rate has been 143, admitted position of the central government. Let's say 143 was indicated first. That's the reported amount. So naturally, 143 has to come to me. But it turns out that 143 never came. Only 70% of 143 came because they continued the earlier reduced split of 70-30 under my margin. So I've not been paid my entire amount. And subsequently now.
So you say that you are entitled to 143.
And the
Who is going to pay that amount for the GPSS?
Same. So actually, the page number 392. That'll actually make the whole equation much clearer. After 391, the relevant part. Running paper.
Yes.
So this is the Food Security Assistance to State Government Rules 2015. And under this, Your Honor may come to the next page, which is 392. This deals with the exact question Your Honor has asked. May I read Rule 4? Rule 4 is duty of the central government. The central government shall allocate food grains under the system from central pool to the state.
So you are saying about page 392, Rule 7.
Rule 7 is the
So you are on the special thing, 100%.
Yes.
Interstate movement and handling.
That's 100.
143 out of 143 plus 17.
Yes.
So it is 160.
Yes.
Out of this 160, 75% will be this.
Yes.
And the center will sponsor this. Now your allegation is that the state have received that amount
Yes.
and have not made the payment to you.
In fact, there's a subsequent development also, because this is what is coming out from the union's affidavit. What happens is in 2015, they declare 143 as my basic money. And so 143 is to be paid to me. 143 is not paid. What they do is pay me 30% of 143 instead. And there's notification that makes the 30%, 70% split. And the 70% comes to me, 30% goes to the authorized agency that they call, which is for the second interest rate handling, movement and handling.
But how can that go to them?
They cannot. And that's my case. They cannot. But that's what they did. And they never claimed the 100 rupees from the center at all. That was the error on their part. That's what I think is happening. That's what seems to be coming out. So there is one paragraph in the respondents.
Yes, you filed your affidavit. What is your stand?
But the project finally comes to the higher within the report at page 37.
Page?
Page 37. Look, they have eight.
Yes.
But from 1/4/2015 to March 2015, they have late and pending, some pending due. Secondly, from April 2019 to 2021. And thirdly, after April 2022, they have sent some amount, but what happens? They have total amount is 146. There is a decision of the state cabinet in the affidavit we have annexed. The cabinet has decided to give one portion to the GTSS and the 100 rupees to the fair price shop. And that was the in 2015 the decision was taken.
But can you do so?
Yes,
Under what provision?
but that is not under challenge. That is not under challenge.
No, forget about that. When he is asking for the entitlement as per Rule 7, you don't need to challenge that cabinet. Can the cabinet do anything which is dehouse the Rule 7? Because you are getting the money from the state, from the center for that amount. You have taken an independent decision to give 100% to the authorized agency. That is your lookout. But the rule says, however it is, you see, kindly see how the payment is to be made. Somewhere it is down the line, somewhere it will be mentioned somehow. How do you pay the additional to the authorized agency will be defined somewhere. This is the targeted, this is the food security assistance to the state government rules. So here you don't have the concept of authorized agency.
There it is.
Where?
The 7. Your Honor has the rule 7 of the TDPS.
What?
Of the TDPS, it's not, I think the. What happens is they have defined authorized agencies as those who do the state government shall lift refrain from the designated course of the corporation through its authorized agencies. Authorized agencies is described as meaning means the concerned department of the state government or a body corporate.
Mr. Counsel, don't digress from the point which I am asking. These food security assistance to state government rules 2015 do not provide anything about the security authorized agency.
Rule 5.
Authorized agency is mentioned in the targeted order.
Rule 5.
And that is for intake. That is for the purpose of intake.
See, it shall be the duty of the state government to take delivery of the food grains of the so and so from the designated, ensure its delivery through its authorized agency up to the door-to-day of the fair price shop and to ensure it. So this is the state government's responsibility. But how can you curtail Rule 7? My question is that where it is only says that this is fair price shop dealer's margin. You, as a you have taken, because that targeted order categorically says that it will be done through the authorized agency. Authorized agency will include not only the government, anybody else, a cooperative society, but also will include the government department. So therefore, if you read the targeted order, it has been given to those persons concerned who has where the government will do on its own or its alter ego types. That is the concept, how it is to be done. It is given, the responsibility is given to the state to do this. But how can you deviate from Rule 7 unless you seek an amendment to that? No, your affidavit is okay, but tell me how Rule 7 can be given. It says fair price shops, dealers, margin. Can the state government take out that margin and give it to somebody else, to authorized agency. Show me that, because here it is a duty. And therefore, the central government is not giving any share out there in that aspect. Because the central government is providing the rice or the food. So central government says that we are giving the food. We have put some responsibility on the state. The state needs to bear the expenses so that it goes to the fair price shop. This is the scope and ambit. Now, how it goes or not, it is your lookout how you put it. But I remember in that Bimal Bora's case, that's the Bimal Bora, na? I dealt with that where there is a cabinet memorandum to that effect, whereby the government says that we are not going to touch on that fair price stop out there. We are going to pay for ourselves this 100 rupees.
But in fact, that was the subsequent development that cabinet memorandum is a part of this agreement also.
But can the cabinet memorandum overrule these rules? No, does the state government is given the power to take out any of these amounts which the fair price owners are entitled?
How we have implemented it. In fact, in 2016, the memorandum is there, but we have again. So the kindly takes up the additional.
Page?
The agreement starts at page 226. But the kindly come to the 228. Page 228.
To 8.
Plus.
Yes. Where is the office cabinet memorandum?
Cabinet memorandum. And we paid, and it.
No, how do you bring the GPSS? You cannot bring the GPSS which is contrary to the rules. Huh?
Page number of cabinet memorandum 434.
I'm reading that. I'm not reading the affidavit. But how do you bring in? Tell me. How do you bifurcate or give it half to the GPS or half to the fair price? Where is your authority?
The reason necessity for modification here, say here. Can you see?
No. Necessity for modification is very well. But can you do so? My question is, can you do so? If you can do so, very well, show me the provision that it can be done. That is why you see the targeted order gives it only to those, but you indulge in having private contractors. The reason is that why private contractors should not be given. Forget about other things. You are actually taking out the money from the fair price shops and giving it to them. How? Show me a provision by which you can modify the rules. Because these are rules made under the NFSA Act. Do you have the power to amend the rules? Huh? No, departmental record, no. My question is very, it's on a pure question of law. We don't require the records. Can you amend the rules? My question is that. If you can't amend these rules, then how do you take care of it? By way of a cabinet memorandum, can you amend the rules?
At this stage, in absence of the record on the background,
why it was, how it was taken. I have. Let me have the record so that the background, the reason how they. What, how they. I'll open here. Because here can you see they have set up this much is the area amount they are required to pay. We have indicated that in margin to this decision for we have accordingly paid. As on today, the entire amount is paid to that and it has been increased to 180. At that point of time,
No, I'm not on that.
I
How are you taking away a part of it? They have increased it to 180, it's a different thing. It's the central government who is doing it. So therefore, you cannot do anything intermingle out there. Who is the central government? You are. Can they do so?
No.
No. Impossible.
I got that. Lordship, that is some time that we actually that we have.
Sometimes means for what? Collecting the money for the purpose of paying it to them. That is another good question. That can be done. No, your stand is wrong. Unless you show me that the state government, forget about that. First of all, cabinet memorandum is not law, by which a law cannot be changed. It has to be notified by way of a notification to make it a law. That's the law. That is the settled principles. So by way of a cabinet memorandum, it may be a policy decision. So by way of a policy decision, can you change the law? No. That. Okay. How much time to get the money? Money? Let them be made richer by the end of the year. End of the year?
This statement, I pray, we not every day that entitlement cannot change. Let me, Lordship is very clear.
I'm not saying that whether they are entitled to 232 crores which they are claiming. No, I'm not saying that. I'm not going to look into that. But the question is, can you take away that?
Lordship, I'll respond to that. For that, to respond to that, I need something. Let me give you something.
Chalo. Heard, Mr.
Yes.
Didas, the learned counsel appearing on behalf of the petitioner.
Yes, for the
And I have also heard Mr.
Yes, for the
T.S. Bhattacharya, the learned counsel appearing on behalf of the Union of India system. This court have also heard Mr. D. Nath, the learned senior government advocate. The petitioners herein are aggrieved by the diversion of the amounts to which they are entitled to in terms with the Food Security bracket assistance to governments bracket rules 2015. By the state government. Full stop. It is the case of the petitioner that these rules are made under Section 22, Section 39 and Section 22 of the National Food Security Act 2013, whereby in terms with Rule 7, the dealer margin, the fair price dealer margin has been specifically mentioned. In the case of the state of Assam, the dealer margin is rupees, fair price dealer margin is rupees 143, which have been now revised to rupees 180. In addition to that, the fair price dealers are also entitled to rupees 17 earlier, which has now been made 26 for sale through point of sale device. The learned counsel appearing on behalf of the petitioner submits that this assistance, this fair price dealers, shop dealers margin cannot be appropriated by the state to pay to the authorized agency in terms with the targeted public distribution system, in terms with the targeted public, what is that order?
Targeted Public Distribution System, Package Control Order 2015.
2006. And more particularly, when it is absolutely within it is the duty of the state in terms with the in terms with the food security bracket assistance to the state governments rules 2015. To provide delivery of the food grains up to the doorstep of the fair price shops. Mr. Dinath, the Learned Counsel, senior government advocate, though submitted that there is a cabinet memorandum on the basis of which a decision was taken for providing part of the margin to the authorized agency and part to the fair price dealers. So this court inquired with Mr. Dinath, the learned senior government advocate, as to whether the provisions of the provisions of the food security bracket assistance to governments rules 2015 can be amended or modified by the state government under any of the powers conferred under the National Security Act and Food Security Act 2013, or even as per the assistance food security bracket assistance to government rules 2015. The Learned Counsel's senior government advocate submits that he would obtain instructions in that regard. This court also finds it very pertinent to take note of the submission of Mr. P.S. Bhattacharjee, the Learned Counsel appearing on behalf of the Union of India, who submits that under no circumstances the fair price shop dealers margin mandated in terms with the rules of 2015 can be diverted to make payment to the authorized agency. Because taking into account that Mr. Dinath, the learned senior government advocate, seeks for some accommodation before vacation. 5th, first day. On before Bihu, 9th, 9/1/2026 for further consideration. What is your matter? Same.
Matter may be detached. Detached.
Let me hear his thing. You will hear you later. Yes, what is your matter?
My matter, kindly fill the page number 48.
What is your matter?
Matter minor, there is a order for 32% for the previous 1 megawatt. To take a decision from the financial year 2021 to 2022, they did not give that.
The instant repetition.
I know.
The issue involved in the instant repetition is nowhere connected to the issue involved in WPC number. There is one, na? 1/2025. And as such, the instant repetition is detached from WPC number 1/2025. It is further seen that the respondents have not filed their affidavit. So considering the above, 4 weeks' time is granted to file their affidavit. This matter on 31/2026. In the meantime, the affidavit be filed on or before 22nd of January 2026. Liberty given to the petitioner to file reply, if any.
8/49.
Who filed?
Petitioners will file now.
Reply. You need some time. Why? Okay. Let us go through together. Not possible. It has been submitted that the petitioner has filed an affidavit in reply today in WPC number 3998/2024. Mr. S. Bhattakur submits that he would obtain necessary instructions. He would like the petition, the respondents would like to go through the same and if necessary and obtain instructions, and he would like to obtain instructions in that regard. First up is this matter on 11th of February 2026.
That is 49. That is 45. This is 49.
Item number 48 to click 18.
160 or 29.
Mr. S. Bhattakur submits that the affidavit will be filed on or before 19th of December 2025. This is the matter on 11/2/2026. In the meantime, the affidavit be filed on or before 22nd of January 2026. Liberty given to the petitioner to file reply, if any.
50.
Ms. Yudas, any instructions? Why? After 4 months also you do it very difficult, yeah? 1 week. It is seen that this court had issued notice as far back as on 22/8/2025. However, the respondents have not provided the instruction to Ms. Yudas, the learned additional senior government advocate, in spite of the same having been sought for. Considering the above, list this matter on 21st of January 2026. Full stop. In the meantime, if the affidavit is not filed on or before 19th of January 2026, this court shall be constrained to pass appropriate directions for personal appearance.
You are.
I'm saying disposed. Non-payment? Then BTC? Tamsir Ali?
52.
Oh yes, 1 month verification and then pay by Tamsir Ali, not time frame. 1 month is verification, that is the time frame I am giving. But then you are going to put you in the chronological list. Whenever you take up work with BTC and PWD, you have to be doubly careful that you have that money and don't wait that tomorrow my daughter is getting married, so therefore I should do and get the money. Never think about with these two departments.
53.
You will get the payment after long time. Don't worry, but you'll get.
54.
Yes, what is your instruction? PWD. Huh? Okay, Tamsir Ali will follow that. Suppose. for finance and PWD.
56.
So Honorable Court has passed a similar order. Election to market settlement. Because we have till date not received the instruction also.
We set aside that, no?
Seems to be similar.
এখন এনেকুৱাতে ভুল দিব খালি ইয়াত তিনিখন মাৰ্কেট আছে 3 মাৰ্কেট ইয়াত হল এখন মাৰ্কেট there is only one market না here which market is this paragraph 1 to অকমান change হ'ব paragraph 4 to হ'ব yeah. The present petition relates to same tender notice now same tender notice 7/5/2025 pertains to the tender notice dated 8/5/2025 issued by the CHD Market and Fairs Department, Bodoland Territorial Council, whereby the respondent authorities have rejected the bid of the petitioner and granted the settlement in favor of the respondent number 6, though the petitioner had quoted an amount of rupees, how much?
2,20,000.
2,20,000. The ground on which the petitioner's bid have been rejected as technically not responsive is that the demand draft, bank draft so submitted by the petitioner favoring the principal secretary BTC was purchased by another person other than the petitioner. The issue involved in the instant writ petition have been dealt with by this court in another series of matters. Matters. One of which is Paresh Brahmo versus State of Assam. Series of matters have been dealt with by this court by an order dated 24/10/2025 in WPC number Paresh in the case of Paresh Brahmo versus State of Assam and 5 others bracket WPC number 4752/2025. Full stop. In the same writ petition, was the paragraph number 3 to 8 being relevant is reproduced herein under. Full stop. Considering that the instant writ petition involves a parameteria question of law and fact, it is the opinion of this court that the petitioner herein is accordingly entitled to a similar relief. Paragraph 9 to Diok, paragraph 9 or 1 to Depot, 1 to delay, arrow number 4 to Depot. 4 and 5. Yes. Post. Same order.
Necessarily given to follow the matter as per Prop 12 of the city file.
I passed that order, same order. Whatever direction was given last time, the same direction.
There might not be, it will not be killed, the example given in amount of the same person. That example is given in amount of.
Here it is not by the same person.
Yes, the same person.
Some fellows, no? Then why you are saying about the same order?
Chairman not written earlier.
Huh?
In the bank has not recorded his name earlier. If you want to handle it and please have it and it's not right. Originally the same. For the term of, bank has not written in name to the draftsman. After it was returned, and he can totally record this time.
Why it was not given then? Yes, what is your stand there? The bank draft was okay.
In name of the petition.
Huh?
In name of the earlier, in payment not recorded, that is like the return. So after correction.
You have to give reasons why you are relying on the judgment.
First, we have not received instruction in this case election. We have indicated the authorities, but they have not received. And the stand is not.
You have not received the instruction, we won't dispose it of it. This court had heard Mr. K. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. N. R. Sharma appears on behalf of the BTC. This court had issued notice on 3/11/2025. However, till date, the respondent authorities have not produced the instructions. It is further seen from the materials on record that the petitioner herein had participated in pursuance to a notice inviting tender dated 8/5/2025 for thereby submitting bid for Baganpara Weekly Market. The petitioner had quoted an amount of rupees 2,20,000. However, the respondent authorities have granted the settlement in favor of the respondent number 6, who had only quoted 1,35,000. So, taking into account that the respondents have not provided them any instructions in spite of opportunity being granted, it is the opinion of this court that it is a prima facie opinion of this court that the granting of the settlement in favor of the respondent number 6 at rupees 1,35,000, that too when the petitioner had quoted 2,20,000, does not appear to be fair and reasonable. Considering the above, this court therefore stays the communication dated 15/7/2025 insofar as the Baganpara Weekly Market is concerned. And all subsequent orders so passed, thereby settling the Baganpara Weekly Market in favor of the respondent number 6. List this matter again on 7th of January 2026.
Yeah.
for education for. Another. Any female education.
I don't like to, this is about the guided response and number 3.
Oh, this one. There's a stay order.
That's the issue.
How much? After 2 years?
No, I don't have anything on demo response number. I want to tell you.
Okay, fine.
They will have-
July.
There is the open.
That is why I'm saying. We have not been active.
We will find out. Yes,
It was, your affidavit is what?
we will find out. We will find out.
What is your stand?
But I am totally. The morning he informed that these are.
This
Anytime I like
this
this
is a very difficult thing which you have done.
Two minor conflicted by the thing.
Huh?
That's fine. So that's the excess.
In many cases, if your stand is against that and you hold him to be good when he has not visited,
No, here by the, what is the allegation, when the private respondent, one after contractor gave in the same joint photo, they may not submitted to panel. What a thing will do.
no. One person went for both.
Same person.
Ah,
No, that I find my affidavit, I will find. Both the party might have jointly might have same time they visited my. That's why they taken photograph by the department. I find my affidavit. It is not the case, not the same man.
Photo, but two are
Yeah.
different contractors,
Different one.
same photograph.
two where?
Two different contractors, my lord. They appeared in the same photograph. So their allegation is that, man, there is some matter
In between them,
there.
two tender.
So that is your stand.
Yes.
Aim of the business, the response number 2 except for favor of the money is only assuming and no evidence. The department acted with lacking is unfounded, in the evaluation process would like to ensure that.
But now they have come up for the repetition after the opening of the finance. Initially, they never. So the petition had come. They also have changes that are very interesting. After the technical because uploaded, all documents are available for every business. Violation for every. Only that thought is to not on the other on the technical what your kind.
So you normally ask 2 persons to take a photograph.
They submitted and accordingly it was issued. Now, when the petitioner raised the issue, then the clarification was sought from the executive. Yes, clarified the result to different.
I've seen the records that day. On the basis of the record, the court inquired with Mr. B. Chaudhary as to whether one of the respondents should not be barred, taking into account clause 6.1 of the tender contract which mandatory requires the bidders to visit the site. Apart from that, the other bidder has violated clause 2.2, which stipulates that there cannot be any cartelization. Repeat case for issuance of notice upon respond number 3 and 4. Who is respond number 4?
Number 3.
You are for 4.
Number
Who is L1? Yeah, we have it in the month of July. Not, when did you receive it? You have not filed it. What to do?
If I put the record, today you can handle the.
I saw the records on that day. After seeing the records, I passed the interim order, na? On 12/11. And that day, Mr. R. Chaudhary appeared. R. Chaudhary appeared, I remember. He appeared. And I said that he has not enclosed the entire tender document, which happens to be very much habitual.
That's part of the additional.
You have got the additional affidavit?
I have not.
The additional affidavit is found out for it, but clear from Bhubaneswar.
I have not. I'm free.
He has not got.
I'll submit
supply to them.
Mr. T.J. Mohanto, the learned senior counsel, assisted by PP Dr. submits that it appears from the records that the response petitioner has filed an additional affidavit. However, the copy of the additional affidavit has not been received. He says, Mr. So-and-so submits that the additional affidavit would be served during the course of the day after vacation. No, not before because no time. Rejoinder, your rejoinder is okay, but the fact remains is this. Huh?
I can give it a week for our phone.
On 19th January.
It will be the first week of.
On 5th crore. 5th crore.
Oh, I can fix one date. I'm not there. 16th of December.
We need to find it.
Nothing is doing there. Nothing. Let them find. 16th of December 2025. It won't be because it's a motion day, one day. And I'm not there, so there will be only one bench more. So obviously there will be too much of matter. So under no circumstances the matter. Huh? No,
What issue might not be, only on that photograph, but there is that only. Whether it gets permission by the person that they are.
you file it on 16th, you will see. And then on 16th, the affidavit be filed on or before. Affidavit be filed on or before 12th. And affidavit by 12th. Interim order passed earlier shall continue till the next stage.
960.
Infructuous.
So far, it relates to item number 16. First request, item 59. But we have held another review about screening committee meeting. In the fourth meeting, we have held the various technically responsive.
Huh?
Thereafter, was found to be as well.
Who?
It is
L12.
as well. And it will be because of.
You were held to be technically non-responsive.
Yes.
So you came.
Yeah.
So they have taken a decision that he is responsive, you are responsive. Now you are L12.
Yes, sir.
So what remains?
The virtual only to that aspect in item number 60. Now you are also, item number 59. We have challenged 2 letters. On the basis of which we were declared as non-responsible. Letter dated 31/7/2025 and subsequent 15/10/2025. These 2 letters are based on workload returns of certain contractors. And we were one of them.
Mr. Whatever may be, you have no business. You are L12.
In that one, we will file affidavit. What will kindly have otherwise this First, you will kindly have this document that I just passed on to
Yes, what is that?
you. Page number 8.
8 number?
8. Internal page.
No. It is what I am looking, he is also giving that. Yes, what is that?
What was para 10?
Uh,
What is the official position?
On further deliberation with the it is confirmed that the requisite so-called notice was not served to so-and-so and the ground for not making no remarks in area is not followed completely as per DBR guidelines here. No, Mr. Counsel, your case is that without a so-called notice, they have taken a decision that these people who have been slow and all, they should be debarred from participating.
Yes, sir.
That is the reason why you came. Now they will take a decision. Then look here, we are allowing you and allowed you and found you L12. So how on earth do you have a cause of action? And the second petition pertains to the first one, you did not challenge something. The second was because of that. Yeah, no, nothing.
What is the kindly observe that 31/7 in future will not further affect the future.
and there you are saying they-
No. 31.7 and 15A cannot affect them unless you issue a suit.
No, there has been extension work, the second extension, there have been even further extension of time.
Ah, you
So in that
extension.
case, if they do not perform again, my lord, will be complying, give notice and then, my lord. No, that is, my lord, that the second extension may remain, my lord, we file affidavit.
Accepted, but that is subject to the future, first, before
The
the.
question is as to whether the communication could have been at all taken into consideration can be ascertained upon response from the concerned demand respondents. So it's concerned and directs the respondent not to issue any work order or enter into a contract with any bidder in respect to the contract in question. So 31.7. While
Second
so it appears the resident-
Further extension of time is granted. So if they comply with the procedure and against the, that contract.
that the application dated. No, but we vacate the stay.
Yes.
The stay has to be vacated.
No.
What is this IA business?
There, I was my non basis of, they're not, basically to increase the other tender.
You don't require now. Okay, first, the Hawk 6362/2025. Heard, Mr. KJ Saikia, the learned counsel appearing on behalf of the petitioner, and Mr. H. Gupta, the learned CGC. Pusto. The present writ petition has been filed by the petitioner, challenging the action on the part of the respondent authorities. Economic, 6026. Challenging. Challenging the decision of the screening committee in the supplementary minutes of the third meeting of the screening committee dated 9/10/2025, thereby declaring the technical bid of the petitioner as non-responsive. It is relevant to take note of that during the pendency of the incident with petition, the respondent authorities had taken a decision on in the fourth minutes of the meeting of the screening committee, wherein the petitioner was evaluated as technically responsive. Further to that, the financial evaluation was carried out, wherein the petitioner was found to be L12. The same minutes of the minutes of the fourth meeting of the screening committee, as well as the documents enclosed to the said communication, are kept on record and marked with the letter X. Taking into account the above, nothing further survives in the instant writ petition. Accordingly, the writ petition stands closed. The interim order passed on 24/10/2025 stands vacated. Wait, the other one. এখন কোথায় ফাইল? এই এখনো ক্লোজ এখন লোগো এখন here you want to file affidavit, huh? Mr. H. Gupta, the standing counsel, learned CGC submits that some time may be granted to the respondents to bring on record their stand by filing the affidavit. Full stop. Accordingly, list this matter on 22/1/2026. In the meantime, the reply be filed on or before 19th of January 2026. There is no interim order. I'm not given in the. Now you have been granted an extension. Then what is there? 54. Okay.
We are not waiting instruction in this case also. Next week, something is going on.
Okay, we pass a stay order. This court heard Mr. S. Hawk, the learned counsel appearing on behalf of the petitioner, and Mr. N.R. Sharma, the learned standing counsel of the BTC. This court, by an order dated 3/12/2025, issued notice asking the senior standing counsel of the BTC to produce instructions as regards the submissions so made on the said date. However, no instructions have been produced. Mr. S. Hawk, the learned counsel, submits that taking into account that no instructions have been produced in spite of an opportunity being granted, the petitioner, some protection should be given to the petitioner, taking into account that the petitioner is the highest bidder. Considering the above, this court therefore, taking into account the recommendations so made by the additional principals, chief conservator of forest CHT Boroland Territorial Council, thereby approving the comparative statement whereby recommendation was given for granting of mining contract in favor of the petitioner, it is therefore the opinion of this court that the petitioner is entitled to some interim directions. Accordingly, this court therefore directs the respondent authorities to maintain status quo as regards the Barnardi Sen Mahal number 13 till the next date. This matter, July? January, no, not possible. For you, it is not possible. In the month of February. On 13th of February 2026. Same order. Ali Barnardi 12. 12, na?
Protest item 31.
Who is appearing? Somebody has appeared on behalf of the respondent number 5. You are appearing. What is your stand? What is the direction?
Direction, my lord, page 3.
Admissible payable within a period of 3 months. Have you carried out the verification? Have you carried out the verification or not? This direction was given in the year 2022. We are in the year 2025. Okay, we ask the person concerned to appear in person. This cannot go like this. Where is your verification? Whether he is entitled to the amount or not? You cannot come up with all these things. Some letter has been written by the contemner. Let us see, so and so, BDO, so and so, physically or without entering the material vouchers. So and so also have received of the matter remanded to the so and so direction. As the purposes of the like, not the sole authority for payment of the material on the amount. To the patient, the report has been waiting for reinstating the ongoing status of the concerned scheme. So that they can pay. So there is no denial to the amount of rupees 7,50,807, page 29 of the affidavit filed by response number 2. Then there is no denial to that effect.
That only because of that kind of regarding one of that MIS. Or the management information, system, that was kind of closed. Because of that one cannot be put in between another. Paragraph 5.5.
Case to, case 26 also, paragraph 5. Only thing, they have closed the escape without uploading my deed. That is,
It is there, look out. It is seen that the respondents, it is seen that in spite of categorical admission that the petitioner is entitled to an amount of rupees 7,50,807, the respondent authorities have not made the payment in spite of an order passed by this court on 21/9/2022 in WPC number 6864/2021. The same prima facie appears to be in conflict with the rule of law and also undermining the directions so passed by this court. Considering the above, list this matter again on 4th of February 2026, on which date the district administration, where is the direction given to? Who is to make the payment? The commissioner of the PNRD department shall provide the head of the account of the said department so that appropriate directions can be passed. We'll attach it.
32 my lord also say.
32.
We fix another date for the yeah. Same there, same order.
And the
33.
I prefer 1 week and 100 time and our driver.
Who?
I'm not a police.
You would like to file a reply to the affidavit filed by the respondents that was given on 10/11.
1 week.
Huh? It is seen that there is no urgency on the part of the petitioner to file the affidavit, inasmuch as this court granted time on 10/11/2025 to file the reply. Taking into account the above, list this matter on 15th of June 2026. In the meantime, the reply affidavit be filed.
Before
Same. It will be by June. Who is to file June? Same case. It will by June 2026.
35.
Yes. N. Bora Dhalani appearing on AS64X for the purpose of filing a detailed affidavit. Filed? Not filed. Okay. So I think we should give away the right of representation through a lawyer and now ask him to appear by in person, isn't it? We have these persons concerned. Now the persons are different. They are there?
Commissioner is there. Yeah.
Okay, so let him appear. What is that? Non-payment of dues?
Yes.
How much?
Well, after verification as per the lordship direction, well, page number 9, they have verified and there is a submission verified by council on 18/8 that he is entitled to 65 lakh, for it is 18/8/25.
How much?
25,
How much is the amount?
in 65 lakh, 62,513. They, well, reported that after the verification, well, they have found that. 15/8, what I, yeah.
Affidavit filed.
One five.
So what is your stand now? Where's my directions? Where's the direction first? Huh?
Page number 9.
Yeah. With the direction to the commissioner, he had to carry out the verification as to whether petitioner is entitled to rupees 76 lakhs. Whether, have you carried out the verification?
Deputy Commissioner, Kasra District.
Yes, I will see every week. Every week, I will every week on that point.
I will bring. Well, the research product is there, earlier. Old, am I in school?
You are appearing for this particular district commissioner.
I know a few of the.
Find out it.
Understood. These are some developments which is now being, one is endorsing to the other. This PNRD department and the district means you always, you are have the habit of creating all these problems, I suppose. No, because in the earlier matter, I have not been able to do pass any orders because of the problem. The district commissioner categorically mentions that he has submitted all these documents and you are not doing it. And now you say that the district commissioner did not submit any document. This is your stand. We do one thing. We can allow you to go and carry out this verification, but any interest will say to be paid on that amount shall be taken from the salaries of these two officials of you. This cannot happen like this. You have filed your affidavit. There was a direction specifically to carry out the verification as to whether the petitioner is entitled to this amount. And if so, then pay.
Page number 100 is the report made by the, as per direction of the commissioner, page number 100. Report is the very report by the DC has submitted this report, that as per direction of the commissioner. Page number 100.
File affidavit, both of you. It is seen from the stand, from the submissions so made by the learned counsel appearing on behalf of the respondent number 1, as well as the learned counsel appearing on behalf of the respondent number 2, that respondent number 3, that one authority is blaming the other. And the resultant effect is the petitioner have not been paid the dues to which the petitioner is entitled to. First, considering the above, considering that there is a specific direction passed for carrying out the necessary verification and to pay within a period of 4 months by an order dated 23/8/2023, this court fixes this matter on 4th of February 2026. In the meantime, both the respondents, that is the respondent numbers 1 and respondent number 3, are directed to bring on record as to whether the petitioner is entitled to the said amount and when the said amount would be disbursed to the amount petitioner. Full stop. No further accommodation would be granted on the next date. It is also expected that the respondent number 1 and respondent number 3 shall settle their disputes, interstate disputes in the meantime.
36.
36?
Maybe should also.
এটা কিমান হয়? 35 না 36? কি? Oh, 6. Yes, what is this?
Your Lordship, I'm for a respondent. Learned, we say here, Senator Booker will be leading the case of person. I will clear my not email fix on Friday or any other day.
What is the direction? Let us see.
Sir, I don't face 27. What if the face 59?
Having regard to the projection, it is provided that till so and so the respondent analyst shall not undertake any further process in terms with the price bid opening tender. Now what happened?
For example, my lord, the same day, my lord, the major friend, my sister, walk. They walk around my lord, court and face 30.
You have filed your affidavits?
Yes, Your Lord.
What is your stand?
Our stand is that Your Lordship, as part of direction, Your Lordship, it was further clarified, Your Lordship, see in the page number 42, Your Lordship. It was
40?
further clarified in the, of the content petition, page number 42. I'm sorry, 52. The last, first, second, third paragraph, Your Lordship, the last line. We also clarified the interim order dated 4/10/2023 shall be in respect to only those tenders where petitioners has participated. Accordingly, we have kept two water tanker available. So there was no such contempt.
Yeah, I have disposed of similar matters.
Similar matter, because it was,
Already, my lord,
What happened in that petition? What?
petition has been allowed.
Huh?
So they allowed my lord on the 26th.
What is that? This petition has been allowed.
Yes.
Then why are you bending upon doing this? Close it. Unnecessary. Because I remember this, it was very difficult to, I felt it, yes. Mr. Ellen Dihinger, the learned counsel, appearing on behalf of the petitioner, and Mr. N. Anik Singh, who appears on behalf of the respondents. The present application has been filed alleging willful and deliberate violation to the order dated 4/10/2023 passed in WPC number 5870/2023. It has been submitted by Mr. N. Anik Singh that the said order, which was passed on 5. The order which was passed on 4/10/2023 was further clarified by an order dated 10/11/2023. And in pursuance thereto, the work order which was issued on 4/10/2023 have not been given effect to. They did not give effect to the.
My lord, this 4 features.
No, did they give effect after this clarification?
Oh, my lord.
They issued the work order, but after this order passed by Justice Buzar Borua, did they give effect to?
No.
No.
Because the matter was.
No, they did not get effect. Further to that, it is also being submitted that by the judgment and order dated
26.
so and so, passed in WPC number so and so, comma, the the repetition have already been allowed and therefore nothing further survives. So considering the above, comma, this court finds no good reason for continuing with the instant contempt proceedings and accordingly the contempt proceedings stands dropped.
57,
You have filed an additional affidavit
Yes.
regarding what?
Case 79. An order of
Direction is what?
paying the property on recovery. Case 70.
Huh? Have you complied or not complied?
There is a stay by the order of Supreme Court.
Stay.
Yes, ma'am.
There is a stay going on. So nothing remains.
Yes, ma'am.
Where is that order?
Page 17, lecture 8 of my additional affidavit.
It has been submitted that the order on the basis of which the present contempt proceedings have been initiated have already been stayed by the Supreme Court by an order dated 7/3/2025 in special leave to appeal bracket C number 4764/2025. Considering the above, comma, the instant contempt proceedings, therefore, is kept in abeyance still the disposal of special leave to appeal bracket C 4764/2025 or the vacation of the order dated 7/3/2025 by the Supreme Court. Liberty given to both the parties to mention the matter upon disposal of special leave to appeal C numbers 4764/2025.
59,
Service not complete. Service having not been complete, then anything you want to do? Anything you want to do?
Steps I can take, but depending upon whether the few incumbents are still holding the post, that I'm not very sure. That has to be very correct. So it's been quite some time now. They keep on changing.
Which department?
This is one department is
What is the direction?
direction of the kind at page 19. The order which they were prepared to basically receive my part payment on which after examination is
The council tell me, how will this payment be made as per Tamsir Ali?
the order.
They don't have Tamsir Ali. Very difficult. Get hold of a PHC council anywhere around the clock if you find it in the corridors. Get hold of it, will pass necessary orders. Get hold. Now, just find out they might be loitering around the corridors.
Right.
Next.
41,
Yes, affidavit not filed. Service is not there. Anybody appeared on behalf of the respondents? Let us have it on some other day. List this matter again on 2nd of February 2026. In the meantime, the respondents are given the final opportunity to file their affidavits.
42,
Oh, yes. Any amount paid? Contempt case, sealing proposal submitted to the finance on the receipt of the concurrent department, Ministry of Finance, and Insurance. How much time?
As early as they are this concurrent, we will.
And how much? We have it for an update on. এই তিনটা matter একেলগে ৰাখিব দেই 440, 441 and 442. Huh? Ms. Ardeka, the learned standing counsel of the Water Resource Department, have placed before this court an instruction issued by the Deputy Secretary to the Government of Assam Water Resource Department, which is kept on record and marked with the letter X from letter Y. From a perusal of the said instruction, it is seen that the Water Resource Department had taken steps for getting the concurrence from the Finance Department, and immediately upon receipt of the said concurrence, the payment would be made. So considering the above, this court for the present is not inclined to issue any notice. List this matter again on 19th of January 28th of January 2026 in the motion column for an update. এই গোটেইকেইটাতে তিনটাতে এইটো Y কৰি দুইটা গোটেইকেইটাতে Y কৰি ফটো ষ্টেট 42, 43, 44.
Limited items 66 to 68.
Oh, your bad case.
Because expected to file our state, I have only filed. And
Very bad case.
it has not been filed.
Whatever may be. What is their case? এই তো দিয়ে গোটেইকেইজন ধৰি পেলাই এদিন dismiss কৰি দিব লাগিব. What right you have?
Their promise, we have shifted to our, to the first floor. At that time, when they have. But even that.
Yes, Mr. G. Bokial, you tell me. Today, as I have crossed the court hours, so therefore I give you the opportunity. Here is a case where initially they were there in that particular municipal market or whatever market they are. After that, they were given an assurance that look here, we will give you in the ground floor or something to that effect. Then they were okay with it. Then this municipal market, they took a decision that look here, ground floor will have parking. Then they filed a writ petition, got an order. And in that writ petition, at that point of time, they were given in the first floor. They were happy to take it in the first floor. Now the municipal authority said that we are having to make a construction on the ground floor. Now they are asking in the ground floor. Any case?
No.
No? See?
At that time, the.
We don't require the other side. Let us dismiss it. The other two matters are there. Together we dismiss all three. আজি মোৰ disposal কাম কেইটা আছে সমস্যা যদি dismiss কৰি দিই
18 plus. 18 plus.
not today then. Let's cross the limit.
In item number 68, there is a status code.
What status quo? No, I am not going to extend any status quo. That is why I dragged that matter out here.
It is continuing now.
Absolutely no. On that day, I couldn't vacate that, no, because that repetition was not there with me. Not necessary. My goodness.
Start the construction and.
Let them construct.
Third party, right?
No, no third party.
They have already said
No. Take it at 66 here. So taking into account the matter, I'm going to list this matter on. Who is the other side? Okay, who appears for Gwalpara Municipal Board? You take your instruction, Mr. Bokel, and you appear. Because the executive officer will be under you, na? Isn't it? Although he has not made him a party.
No, he's not party.
He has not made him a party. But anyway, the executive officer will be there.
Right.
So executive officer, inform him, he's a government officer. Isn't it? He's a government officer.
But
Okay, so inform him any peer. Okay? Very good. Mr. G. Bokhial, the learned counsel, appearing on behalf of the respondent numbers 1, 2, and 3, also submits that he can obtain instructions from the executive officer of the Goalpara Municipal Board in respect to the present matter. So taking into account the above, the service is duly complete, this is for admission on, you want the dismissal before vacation or after?
That yes.
After, on 7/1/2026. What is it?
70 and 71.
69 to give. You are paying for 69, no? The 69 number, please. Just 1 minute. 69 is there, Madam Astro is waiting. Did you get hold of our PhD?
No, my lord, I have tried to call one of them, but unfortunately, he has left before payment.
Okay, itu item tu tentu asal. We have it, let us have it on sometime on, let it be on 17th, 18th. Huh? 18th? Liberty to mention the matter for upgrading. Let's see, then we catch hold of that person. No?
69.
It is the question of compliance, getting in compliance.
On 18th, my lord.
I'll list the matter on 18th. Liberty given to the petitioner to mention the matter for upgrading.
I'm happy with it.
Service complete. Receive the above notice on demand and put their seal. With the response number 7 and 8. Dubri, Gaon Panchayat. Okay.
Your Lordship is directed to take instruction whether the area falls under the municipal area or Gaon Panchayat.
Hmm.
And in persons to this order, I have filed an application before the
Okay, service is complete. Service is complete. Well, the 5 only does, otherwise the service is complete. 8 is also a period, the service is being done. Okay. This court have duly taken note of the affidavit of service so filed by the petitioner. So taking into account the said affidavit of service, the service is duly complete. So considering the same, list this matter on 16/12/2025 for admission. It is further observed that on the next date, this court shall consider as to whether there is a necessity of passing any interim directions.
70 and 71.
Yes.
Yes, so we have filed our affidavit. In item 70, they have filed the reply there. And 71.
Where does Mr. Fupon appear?
Yes, my lord, I appear.
JP Buragoy or Rajiv Hazarika?
I appear for JP Buragoy, my lord.
And you for Rajiv Hazarika?
70.
Matter pertaining
Yeah.
to pinching.
Yes.
Now, in this second writ petition which is being filed, is the third time writ petition. That is it. And what is JP Buragoy's matter?
That is for the challenge to a tender funds.
The second one.
Oh, that has become this. You have
That
given
enough?
somebody, no?
What they have already supplied the.
His case is that there should not have been individual one person itself, no?
Earlier it was.
No, my lord, the previous NIT I qualified, but the subsequent NIT I could not qualify because of the terms and conditions, my lord.
Hello? How many years? 5 years, na?
5 years, my lord.
He'll do it leisurely. No urgency, na? Leisurely.
In this case, the Lordship,
I had challenged it, I had challenged the eligibility criteria, technically qualified of the everyone here, because he has not signed an MOU.
Oh, yes, MOU.
So that kind of document observe, if there's necessity of facilitating on the next.
Your
I
lordship,
will
that
consider it.
left the maintainability open, taking into consideration the fact that on merit, the litigation has already been disputed.
Now, who is appearing for the respondent? Oh, in my court, that submission doesn't work, that I file a wakalatnama. I always believe that filing an affidavit is the necessity. 1 week?
Yeah.
We have it on 18th. File your affidavit.
And that what going this year, they're activated on Friday. I will also going there.
You want to file a reply. And JP Buragoy will consider later on.
I'd be grateful, my lord, if it could be considered, because I do believe that I have a case
You are
and
there,
I believe that,
you are there in Delhi.
no, my lord, I'll come back tomorrow, my lord. 18th is no problem.
You are in Delhi.
No, my lord, I'll be coming back tomorrow. I'm not in Guwahati today.
Okay.
Yes,
Well,
ma'am.
take your time, come back slowly.
No, my lord, I'll come back on 18th. My lord can fix it up on 18th. My lord can hear me on 18th itself. My lord may not push me behind. I should be taken
No,
together.
I have kept it together because of the fact. How many types of repetitions you keep on taking for these 5 inches, 12 inches?
In all, I think this must be the 7th or the 8th.
Ah,
I have only filed one, my lord, and subsequently the new NIT came. Therefore, I filed this one. That's all, my lord. I have not filed more than that. So at least don't push me, my lord, to that. I'll be grateful if it could be heard together.
okay.
Extremely grateful.
And 6369/2025. The respondent ONGC have already filed the affidavit in opposition. Mr. R. Sharma, appearing on behalf of the petitioner, submits that he would like to file a reply. Mr. L.N. Dehingi appears on behalf of the private respondent number 5 and submits that the affidavit would be filed on or before 18th of on or before 17th of December 2025. List the matter on 18th of December 2025 for admission. This court shall consider as on the next day as to whether any interim orders are required to be passed. JP Buragoy interim has been rejected. No.
Yes, my lord. The first date was not granted. That, my lord, was on 13th of August, my lord.
Mr. R. Sharma appears. How can you appear for both? No, you can't appear for both. Taking into account that he wants, that particular person wants to contest and wants the tender, and he's appearing for challenging the tender. You can't appear for.
I will withdraw.
Huh?
I will withdraw.
I think we should delink, otherwise it look very poorly on the conduct of the council. Or we should have it in some other bench. This matter.
No, my lord, I would request it to be left.
So we say that let it come up in bench 3. Not with, I'm not saying about not from my court. Let it be in bench 3. Then nobody will know.
Well, my lordships already knows about it, so it will be much more fairer for us.
No, Mr. Pukon, the same council, one council is challenging the terms and terms of the same tender, and that same council later on is challenging that I should get it. We have it this on some other day. This matter for admission on 28th of January 2026. You withdraw from here, otherwise it shows volume.
My lord, it'll be in your lordship's benches itself.
Who? Petitioner files a rejoinder. That's you know it. What are the terms of the rules? Guwahati High Court rules for admission.
Okay.
Excellent.